Okay, welcome again, all of you. We are right on time. The pledge you made yesterday, Mr. Lustinao, is still valid today, so you don't need to repeat it. So unless there is anything that the parties want to raise, I'll give the floor right away to Mr. Fleischmann. Okay.
Melsheimer.
Fleischmann. My apologies. By the way, one minor point is you pause slightly between answer and question. Again, Mr. Melsheimer.
Good morning, Mr. Lustinao.
Good morning.
I want to go over a little bit your direct examination yesterday, your testimony. If we could pull that up. And if we look at page 450. Once we get to page 450, you explained that you started as being the legal manager for private law litigation at Pemex in 2017. What were you doing before that at Pemex?
I worked on the staff of the person who at the time was the head of the litigation subdirectorate. I was a sort of advisor providing support and as a member of his staff.
And so when you say you were supporting the entire area of the legal team within Pemex?
No, it was more support for the assistant director at the time, not all the areas.
Boss.
At that time, in 2016, it was Alfonso Guatirojo. Afterwards, in 2019, it was Ms. Maria Elena Mendez. And after that, in 2020, I took over as assistant director.
At 2015, correct?
Yes, that is correct.
Mr. Guatirojo started at Pemex in 2015 also, correct?
I understand that it is, according to my recollection.
So before... Did you know Mr. Guatirojo before starting at Pemex?
Yes, I met him when I was in my undergraduate studies. He was my professor, and I later worked in his law firm.
So is it correct to say that you and Mr. Guatirojo worked together before you both started Pemex?
Yes, that's right.
Moving on to page 451 of your testimony yesterday. As I understand, you explained that there are silos within the Pemex legal department. Is that correct?
I'm sorry, you said silos?
From your testimony yesterday, I understand that various departments within the Pemex legal department are compartmentalized. Is that correct?
Yes, there are several different departments in the legal office, and they have different functions based on Pemex statute or bylaws.
But from your testimony yesterday, I understood that these departments do not communicate with each other. Did I understand correctly?
The departments of Pemex?
Areas within the legal department of Pemex, do they communicate with each other?
Yes, there is communication. There are matters that merit communication. But each of them has its particular area, its specific functions, and its statutory powers.
Yesterday you testified that there was no possibility of you being involved with the administrative rescission of the 821 contract. Is that what you said yesterday?
Yes, because the area is the one that is authorized to administer the contracts. It's the one in charge of issuing work orders, supervising the contract. Everything related to performance of the contract is done by the area that administers the contract. And in response to breaches detected, it was the area administering the contract that carried out the rescission procedure.
You mentioned again, as you did yesterday, the administrator of the contract is the person who carries out the administrative rescission of a contract. With respect to the 821 contract, who is that person?
I don't recall the specific name of that person, but I think that can be corroborated easily in the record. It's easy to find out who the administrator was. In general, the area that administers the contracts is under the productive enterprise with which the contract is signed, not a person from the legal office. It's an area that is under the productive enterprise of the state. In this case, PEP. The contract was administered by the Department for Exploitation Services, and no doubt there was a department that was in charge of administering that contract, or an office in charge of it.
Are you familiar with the name Luis Gomez?
From the record and from what I was hearing in the hearing, I understand that he was the administrator, no doubt, because he was the one who signed some official communications.
So is it fair to say that Mr. Luis Gomez would know about the administrative rescission of the 821 contract?
Well, if he was the administrator, no doubt, yes.
Is he still employed by Pemex?
No lo
That I don't know. Indeed, I don't recall this person, Luis Gomez. I can't identify him. I don't recall having had any personal interaction with him.
You're here on behalf of Mexico, correct?
Well, not on behalf of Mexico, but rather I am a witness offered by the United Mexican States. But I see myself more as a part of the evidentiary record. I don't see myself as a party or as an attorney for Pemex, Mexico, or for Mexico.
You are aware that Mexico appointed you as its party representative for this arbitration, correct?
I understand that that is right.
Move on to pages 452 and 453 of your testimony yesterday. You were asked if you knew the reasons why Pemex Exploration and Production rescinded Contract 821. You responded that it's your understanding because of the various breaches. What breaches are you referring to?
Well, from what I know of the record, based on what I've reviewed, I understand that there were several breaches, the first of which was a breach of work orders, not abiding by the orders of the representative of Pemex, carrying out a change in domicile without giving notice of it, and the breach of the PACMA programs.
So are you testifying that Pemex had the ability to administratively rescind the 821 contract because of one unfulfilled work order?
In terms of the contract, yes, in effect, Pemex could go forward with the administrative rescission of the contract. And in this case, it doesn't seem to me that the only ground was the failure to fulfill one work order. It was several that merited and justified rescission of the contract. It wasn't just the failure to fulfill one order.
That's not my question. My question is, are you testifying that Pemex had the ability to administratively rescind the 821 contract because of one unfulfilled work order?
Well, even though that hypothetical is not what happened, I would say that Pemex, with the breach of one work order, which meant a breach of a substantive obligation of the contract, did have the power to be able to administratively rescind the contract.
You continue on page 453. You speak about clauses on administrative rescission, such as this, provide for a proceeding in which one is guaranteed a hearing. Do you see that?
Yes, I see it.
And who is this hearing
Señor
before?
presidente, una petición.
So, at one request, President, I don't want to be disrespectful toward the claimant, but insofar as possible, I imagine that the claimant prepared the examination yesterday, but insofar as possible, it would be useful if Mr. Rodrigo Lozano could be shown the transcript in Spanish.
Version of the, yes, I think there is.
Por supuesto
So-
que la hay. Y la hemos
Yes, of course, we've been receiving it every day.
Switch in a few seconds to, would you object to having the reference, you speak Spanish, so probably you made reference to specific paragraphs of the, so if you could show the Spanish translation. But in the meantime, as we are short of time, why don't you continue, and as soon as the Spanish version is available, we'll use it.
se lo agradeceremos.
We'd be most grateful.
Who is the administrative hearing before that you referred to yesterday with respect to an administrative rescission?
There are various forums where one has the opportunity and one is given the guarantee of the provider is given the guarantee of a hearing. The first of these is carried out before the area that administers the contract, that is to say, before PEP. That's the first opportunity, which is to say, once one receives notice that the procedure has been initiated, then they're told they have time X to present their arguments, their evidence, to try to refute the allegations of breach that are being made. And then, if the rescission of the contract is decided, because the rescission proceeding doesn't necessarily end in a rescission. In a case like this, where the administrative rescission was confirmed, subsequently the provider has the right, I was saying, to a motion for review, which is brought before the person in charge of whoever issued the administrative act, or one could turn to an administrative proceeding, to administrative litigation before court.
So in short, the contractor first has a hearing before Pemex, correct?
Yes, that's right.
And Pemex is part of the executive branch of the Mexican government, correct?
Well, it is a productive enterprise of the state. It's complicated to define its legal nature. It is a productive enterprise of the state, which, by constitutional mandate, has the objective of generating value. But situating it in one of the boxes of the federal public administration is complicated. So I wouldn't be so categorical about that, because there are principles of corporate governance, it has operational flexibility, it has a special regime in respect of government, in respect of debt, in terms of contracts or procurement, in terms of remuneration for staff. It has a special regime that makes it such that it's not feasible to situate it, as you state categorically, as part of the executive branch. No doubt it is a public enterprise.
Okay, but my question was a little more straightforward than that. Is Pemex within the executive branch of the Mexican government?
Well, it's a special category. Productive enterprises are, and they are part of the government, of course.
Yes, Pemex is a part of the executive branch of the Mexican government.
Señor Presidente,
Mr. President, it's the third time he's being asked the same question, and he's answered it. I think the witness is cooperating with the claimant. He's been asked the same question 3 times.
So if there is a repetition of the answer, that's not wrong. So they are using the times. So please continue. In the meantime, do we have the Spanish transcript?
Can you answer my question?
It's not that I don't want to answer it or that I'm trying to elude it, but if you review the organic law of the Federal Public Administration, you'll see that it says that the Federal Public Administration is made up of different offices known as dependencias and others known as parastatal entities. And the dependencias include the state secretaries and the legal office. And then under state enterprises are those enterprises where there's majority public participation, public trusts, national lending institutions, national insurance and bonding institutions, others, companies where there's majority state participation. But nowhere in that list that defines what is the public administration of Mexico, that list does not include the productive enterprises of the state. For that reason, that's why I say it's not. One can't categorically say that the productive enterprises of the state are part of the executive branch, because in the organic law and the Federal Public Administration, they are not included in that list. And that can be corroborated easily in the statute. There's a list.
You testified that it was common for lawyers representing a party to meet with judges. Do you remember that?
Yes.
Correct to say that only the lawyers who are recognized with the court are those who can meet with the court?
Yes, naturally, yes.
Look at Exhibit C127. I believe we looked at this yesterday. The names that are in bold, and just for background, this is Pemex's answer to the request for nullity of the administrative rescission of the 821 contract, correct?
Can you give number?
C127.
Sí, lo veo.
Yes, I see that.
And you agree with me that this is Pemex's answer to the request for nullity of the 821 contract, correct?
Yes, it's the answer to the action by Pemex.
That are in bold, those are the people who the court would admit for these conversations that you testified about yesterday, correct?
Oh, well, actually, these are the persons authorized to send or receive notices, but that is a common practice in Mexico that the persons who are authorized can go before a judicial body to discuss a matter.
Yesterday you testified also that you were not authorized, or maybe the better word is it was not within your purview, an administrative rescission of the 821 contract until, I believe, the year 2020. Do you remember saying something similar to that?
No. Not in 2017 nor in 2020. I was never authorized, or it was never within my purview to declare the administrative rescission of the contract.
Name appears on a submission to a court in 2017 regarding the administrative rescission, correct?
No. This is the answer brief, the answer to the action, but that doesn't mean that I'm authorized to effectuate the rescission of a contract. Not when I was a manager, not now as assistant director. In contracts such as this that include clauses such as the administrative rescission clause, the one authorized to carry out the administrative rescission of the contract is the area that administers the contract. No area within legal is authorized to rescind a contract, not today, not yesterday, not in 2017, and not in 2016.
So you were involved in the legal actions with respect to the administrative rescission of the 821 contract, correct?
I participated and I was in charge of the regular federal civil proceeding, and I was authorized to the answer here and the answer to the complaint. That's a common practice. I don't think that being authorized in a file gives you the functions of another area. Not at all.
Who authorized you to be listed on this answer?
The Assistant Director for Exploitation Services of the General Director General of the company, of PEP.
Did you, and what's the name of that person?
That's Rodrigo Hernandez Gomez.
remember correctly, he's the same gentleman that signed the administrative rescission of the 821 contract, correct?
Based on what I see here, that must be the case, but it would be worth reviewing the administrative rescission because I don't recall that. Administrative rescissions can be signed by an official who has statutory existence. So in Pemex, that is the case of the managers and the assistant directors and, of course, the directors. Now, I don't recall whether he was the one who signed the rescission. I think it would be worth looking at it.
So help me understand. You were part of a different department within Pemex's legal area that does not involve administrative matters, but Mr. Rodrigo Hernandez asked you to be a party, or excuse me, a lawyer with respect to a challenge to an administrative rescission of the 821 contract. Is that my understanding? Is my understanding correct?
No. No, it's not correct. He did not appoint me as his lawyer. He named me as a person authorized to send and receive notices along with 20 other persons.
Mr. Hernandez, about being appointed for this task?
No. Rather, the administrative litigation area was the one providing support and advice in drawing up a legal brief, as is an answer to a complaint, and it's a very common practice for in both the administrative area and the private law area, as well as in criminal and labor law areas. The managers are authorized should there be a case where the manager, in this case it was Said Castaños, isn't present or has to become absent, and some step needs to be taken. Moreover, it's more of a precautionary and support measure as between the different offices. And that does not mean at all that translates into me having been appointed the lawyer to handle this matter. Not at all.
Yesterday you also testified about first meeting Mr. Roberto Cayosayan around 2017. Do you recall when in 2017 you met him?
I don't recall, but it must have been in the mid-year or towards the end of the year.
You also mentioned, in connection with meeting Mr. Roberto Cayosayan, a company called Key Energy. Do you recall mentioning Key Energy yesterday?
Yes, it was one of the matters for which he wanted to be hired to handle it.
After your testimony yesterday, I looked on the internet and I saw that Key Energy was entered into let me rephrase, the Securities and Exchange Commission of the United States issued an order with respect to Key Energy for violating the Foreign Corrupt Practices Act. And that was in August 2016. Is it possible that you had met Mr. Roberto Cayosayan in 2016?
No.
No, I don't remember having met him in 2016. It was rather in 2017.
Porque aparte,
In addition, in 2016, I had not yet formally taken charge of the litigation management, so there was no way I would become involved in matters in the United States.
You also testified that Mr. Cayosayan And actually, if we could, is the Spanish transcript available? Because I want to be clear about the questions. If we could go to page 455. It's not the same pages. Yesterday you were asked if Mr. Keosayan or the law firm in which he worked or works provides legal services to Pemex or any of its subsidiary companies. Do you remember hearing a question similar to that?
I recall that I was asked, what I was asked is whether Mr. Keosayan provides legal services to Pemex or to some of the subsidiary project enterprises. Yes, that was a question.
Has Mr. Keosayan or the law firm in which he worked or works provided legal services to Pemex or any of its subsidiary companies?
As far as I know, no. He never provided any services to me. I never hired him. No contract was awarded to Mr. Keosayan or to any of the law firms that he mentioned.
When you say his firm or his employer, are you referring to a specific name of a firm?
Yes. I wasn't really clear whether he was a shareholder or a partner, but he said that he had the legal representation in Mexico of a firm in Texas called Manny Gonzalez Felix.
So you're not aware that this law firm, Manny Gonzalez Felix, represented Pemex Exploration and Production in various litigation in the courts in the state of Texas?
I never hired him. When I took office as a manager, I never hired him, and I do not recall whether he provided any kind of service on the matter.
Never hired. You're referring to you personally not hiring him, not Pemex hiring him.
No.
No. Ever since I took over the office, Pemex, or any of the protected companies, none of them hired him.
So Pemex Exploration and Production did not hire the law firm of Manny Gonzalez and Felix to represent it in the case against ConocoPhillips in the United States.
I do not have personal knowledge of that.
Pemex Exploration and Production did not hire Manny Gonzalez Felix to represent it in the case against BASF Corp in the United States.
Not.
I do not have knowledge of that.
Pemex Exploration and Production did not hire the law firm of Manny Gonzalez and Felix to represent it in a case against Murphy Energy Corp in the United States.
I do not have personal knowledge of that.
Pemex Exploration and Production did not hire the law firm of Manny Gonzalez and Felix in a case against Big Star Gathering in the United States.
I never had personal knowledge of that. Ever since I took office, no contracts were awarded to Mr. Kosian or to the law firm Manning Gonzalez Phillips. This was not done personally or on behalf of the productive subsidiary enterprises.
Before we get to some other questions in more detail, since you're here you are Mexico's representative for this arbitration. So I want to ask you a question about something that I heard during the opening statement. We were told, with respect to the drilling authorization to drill the Coapachaca 1240 well, that a contractor drilled that well. Do you know the name of the contractor who drilled that well?
I do not know.
We were also told that a company called Weatherford provided information to Pemex in order for it to obtain the drilling authorization in order to drill that well. Is that true?
Señor Presidente,
Mr. President, I need to make a clarification. Mr. Rodrigo Lustono is a witness for respondent in this arbitration. The only reason why he was appointed as a representative was for him to be able to be here at the opening. That's first. Second, when we did the answer to the comments by claimant, we said that Weatherford comes, the name of Weatherford comes from the memorial of the claimants. And third, Mr. Lustono is part of the management office of...
Sorry. I was saying that you are right to the extent that Mr. Lustono is here acting as a fact witness, and at the same time he has been appointed Mexican representative to participate in the opening statement. But as a senior official of PEP, I think he can respond as a fact witness to any question raised by the claimants, and if he doesn't have the answer, that's too bad. So I think claimants are entitled to ask the question, and you are acting here as a fact witness in that capacity, not as Mexico's representative in general. So please, you can continue.
¿Me puede repetir la pregunta?
Please repeat the question.
We were told with respect to the drilling authorization to drill the Coapachaca 1240 well that a contractor drilled that well. Do you know the name of the contractor who drilled that well?
I don't have personal knowledge of that. I don't know who did it.
Por favor,
Pemex drills thousands of wells, hundreds of wells a year. How would I specifically know who drilled a well more than 5 years ago?
That a company called Weatherford provided information to Pemex in order to Pemex to obtain the drilling authorization in order to drill that well. Is that true?
I don't have personal knowledge of that.
conozco.
I know about Weatherford. I know it's an international company. It's a very important company that provides a number of services to Pemex. But I am not aware that Weatherford had provided information. The administrator of the Weatherford contract, if that were the case, and the administrator is the one that asked for the services, he would know or she would know.
Well, this is the same well that Pemex claims Finley was supposed to drill. So would the contract manager for the 821 contract have that information?
I don't know, because Weatherford provides a number of services to Pemex. It does not only provide drilling services, it provides information services, it provides slurry services, ship services, input services for production purposes. It provides many, many services to Pemex. Weatherford does.
So let's turn to your witness statements. And let's start with the first one. On the cover page, you said that the information herein provided is strictly confidential. And I'm reading from the English.
Sí, de acuerdo.
What's
Agreed, yes.
in your witness statement? What is confidential in your witness statement?
Pues entiendo.
Well, I understand that the contents of my witness statement.
In paragraph 6, you mention in 2017 that one of your functions was to propose and direct the strategies for an adequate defense in the lawsuits in which such matters that Pemex and its subsidiary productive companies were facing. What do you mean by that?
Well, this was the legal office in charge of private law matters, civil and business matters. Well, we handle everything related to a lawsuit.
Someone with respect to the 821 contract would have sought your advice if there were legal issues involved with respect to that contract?
Not necessarily, because there are other offices within the assistant director's office that provide support to the subsidiary productive enterprises. Back then, we had in the assistant director's office of regional operations, we had the litigation sector, we had legal advice sector, and then we had another one which was called partnerships and new businesses. So the advisory path for subsidiary productive companies is not the litigation office, but the advisory office.
In general, does your legal department have a responsibility when it comes to transparency requests made to the Mexican government? And let me ask a better question. If I were to make a transparency request to Pemex Exploration and Production, would you have responsibility with respect to that request?
No.
Can we look at C-141? I'm showing you C-141, and this is a transparency request that I made to Pemex Exploration and Production. I'll give you a chance to read it. the response I received to a request for all information about work order 28-2016 was that there is an arbitration involved, and I couldn't receive that information under my transparency request. Who gave that information to the Transparency Department?
There is an office that deals with transparency requests, and they look at the matter and they send it to the relevant office. These companies had a litigation with Pemex, so apart from sending this to the 821 Contract Administration area, they also sent it to the legal director's office. And we took notice that this arbitration was pending, and we were the ones who provided that information.
So your department was behind the response to my request to get information about work order 28-2016?
When was the request placed?
Ok, pues seguramente
Very well. Surely then, my office that coordinates these matters with the Minister of the Economy, we were the ones who provided the information because we knew of this arbitration. There are a number of grounds in the transparency law that allow a government entity to reject a request. For example, when a matter is part of an ongoing legal proceeding that is in the law. If the private party does not like this rejection by the authority working in the transparency field, the private party has certain remedies that it can resort to. And INAI, a constitutional autonomous body, will have to decide on that dispute.
That I made a similar request for documents related to work order 28-2016 as part of this arbitration, correct?
'28, 2016, you said? Is that the one you said? I didn't hear that right.
You are aware that we, the claimants, made a request for similar documents as part of this arbitration, correct?
I do not have personal knowledge of that. I don't know if whether the request for transparency was included in the same request that you put in this arbitration.
no lo sé.
I do not know.
Can we pull up, I believe it's R124. Mexico introduced this exhibit. It's been translated regarding the responses or the document inquiries searches that were made within Pemex for responses to our requests for disclosure in this arbitration. If we could go to page 2. You were copied to this response, correct?
Yes, that is correct.
Mr. Arturo Soto Barrios works for you, correct?
He is, yes, the legal manager for private matters.
With respect to the request that we made for disclosures in this arbitration.
When the request was put to us, I remember that we sent the information to this office because that's where the civil lawsuit was being handled. We looked at the files that were reported to me. We looked at the court file. And we looked for any document that was related to the contract.
Señor Presidente,
Mr. President, to the extent possible, if he could be shown the Spanish versions, that would be useful. He's testifying in Spanish, and the documents are translated.
Extent that if you can show him the originals in Spanish, that would be better. But again, we are somewhat short of time, so I want to see if you can easily retrieve the Spanish version, fine. Otherwise, you can show it on paper. Probably that's a good alternative. And
perhaps somebody can sit next to witness and help him, just to expedite the process.
solo una acotación, señor Presidente.
Just a clarification, Mr. President, it would be very useful for everyone to be courteous in this meeting, specifically vis-a-vis the witness. Procedural Order 9 is very clear. The documents must be used in the electronic hearing bundle. The electronic hearing bundle has both versions. Then he could be shown the documents in Spanish instead of putting all the documents at the foot of the witness.
Sorry. I was somewhat startled by dropping so many documents down there. So the key thing is, if you can not show the Spanish version, you just point to the page in the file, in the written file, and that will be easier.
You did receive the request for disclosures that we made in this arbitration, correct?
I assume so. In this official letter, we're addressing that matter.
Is that a yes?
I do not recall whether the information that you were requesting was shared with me, literally, but yes, documents were asked of me for this arbitration, but I do not recall whether everything that you requested was what they requested of us.
At Exhibit R121.
Señor Lustino?
Mr. Lustino, you understand English, okay? At least written English, you understand it. Is that correct?
Entiendo, pero me gusta.
I understand it, but I would want to see the Spanish version.
That's your name at the top of this document, correct?
Sí.
That's right.
And if we go through this document, it lists all of the requests that we made, correct?
This is an official letter from the Minister of the Economy sent to me. This is not your letter asking for documents.
So I want to talk about the extensive search that you made in your files in response to this request that was made by the Department of the Economy. And let's look at C-103. This is a memo that you wrote on May 8, 2017, correct?
Yes, that's correct.
There's a box that says Anexo. That's checked, correct?
Sí.
Yes.
And in the text of your memo, you say a May 3rd memo is attached, correct?
Yes.
Were you able to find the May 3rd, 2017 memo that was attached to your May 8 memo during the extensive search that you made for documents responsive to the disclosure requests in this arbitration?
Yes, a search was conducted, but we did not find it, truth be told. We can see the acronym here. This was not our official letter. It was an official letter of PEP, General Directorate Services for Exploitation of May 2017. And the correspondence and the files are cleared up. And this was not our official letter, and surely that's why we were unable to find it in our files. So we sent this at the time, and we were not able to find this official letter.
Were you able to find your May 8, 2017 memo in your extensive search?
Yes, so much so that it's here.
Where's the attachment?
No lo encontré.
We were unable to find it. But truth be told, well, what I think is relevant, apart from these internal communications or these internal official letters, well, I think that what's important is that for purposes of the rescission vis-a-vis the provider, in this case Drake, is the commencement of the rescission and the administrative rescission as such. These are the acts that have effects vis-a-vis the provider. And we need to include in those acts, in those documents, every single one of the reasons why the rescission is beginning, and then you have to include why the rescission is taking place. So there is no reason, no cause included in this document. The provider knows of these documents, and the provider can challenge these documents and can provide answers to these documents, of course.
What was in that May 3rd, 2017 memo?
I do not recall, truth be told, but from what I see out of this memo, I see that the administrator of the contract, and I know this because of the acronym here, it says PEP, which means PEM Exploration and Production, and then DG, which is the Dirección General, and then we have the Subdirección de Servicios de la Explotación, and then we have GSIAP, which is another office. So what I'm saying here is that amongst other things, you were requested to proceed to notify the start of the administrative rescission of contract number 821. From what I read out of this memo that I wrote, there is this official PEP document. Well, the contract administrator is asking the contracting manager to start the administrative rescission proceedings.
So during your extensive search for documents responsive to our disclosure requests, did you ask this area for the May 3rd memo?
I do not recall whether I did this. I personally did not do it. But what my colleagues told me is that they were unable to find it because this subdirectorate of exploitation services had its functions changed starting in 2019, and the functions that it had before were sent to other offices. So when there was a transfer of files and transfer of contracts, perhaps this document got lost, got misplaced. So what I think is relevant, apart from any internal communication that one may have, such as this or many others, for the purposes of the provider, the important thing is the beginning of the proceeding and the rescission itself. We provide the provider all the reasons why this happens. All of this is in that document. You cannot have one reason that is not included in those documents.
En el inicio y en la rescisión.
In the commencement of the rescission proceeding and in the rescission proceeding itself.
When we started our questioning, you told me that you had no involvement with respect to the administrative rescission of the 821 contract. Why are you asking about the administrative rescission of the 821 contract in May 2017?
As we can see from this communication, I did not ask for the rescission of the contract. What I said is that once the rescission was finalized, I needed to have it because I needed to show it as part of a proceeding. This by no means implies that I ordered
Del inicio.
the notification of the beginning or that I had ordered the administrative rescission. The legal department has never had that ability, that power to do so. We do not administer contracts.
About the administrative rescission of the 821 contract before writing your May 8th memo.
Por lo que
From what I see, the administrator on May 3rd had asked the supply area to notify this rescission, and we can also see that this was the beginning. If Drake had appeared and evidenced and also explained that the grounds were not correct as they were being charged to them, the whole case could have followed a whole different situation, but they did not deny those grounds. And finally, when the rescission was issued with the highest courts in Mexico, the rescission was confirmed, was upheld.
We're reaching an hour. Is it good for the court reporters? When I look at the dates, May 3rd, I believe, was a Wednesday. May 8th was a Monday. Why are you writing a memo asking to be noticed or notified about an administrative rescission that Monday?
la verdad es que
To be honest, I do not know. Why on a Monday this communication was sent on May 8th? Is that your question?
But your email says, or excuse me, your letter says, you need to know within 3 days of the administrative rescission in order to introduce it as part of your ongoing civil litigation with respect to the 821 contract, correct?
No. What I am saying in this communication is that if the rescission is issued, there is a need to receive it within 3 days so that I can attach it to the other proceeding, the civil proceeding that was underway. Because as part of that civil proceeding, Drake was arguing that there was non-compliance by PEP since the work had not been complied with, and our position was that I am not in non-compliance because I am not compelled to issue work orders non-stop. And when I saw that on May 3rd, they were requesting the notification of the initiation of the proceeding. This is something relevant for the proceeding. With that document, I could show that Pemex was not in breach.
Correctly, and it may be the translation. You received a May 3rd memo from Mr. Musalem unexpectedly?
The May 3rd communication does not come from Musalem. Musalem was just an alternate for exploitation services, and so that office was part of an area that was called Operational Office for Procurement. And what I am saying is that this May 3rd communication was coming from the contract administrator. So those are different areas. What I see in this communication by PEP, that the contract administrator is asking for notification of the beginning of the proceeding and the initiation of the proceeding, and that's when I noticed that if there was going to be a rescission proceeding, and if that contract was rescinded, within 3 days of that, I needed to receive that information to attach it as evidence as part of a litigation that was linked to that contract 821.
Maybe I'm just asking a bad question. Why did you receive the memo on May 3rd?
Pues usted,
As you may have seen throughout the communications, this is normal practice, regular practice within Pemex to indicate a copy for everyone that may have something to do with something related to the contract. And I had something related to the contract because there was a litigation, a civil litigation derived from this contract. So certainly I was marked as someone that had to be copied, or I learned of this communication that was requesting initiation of the proceeding.
But you didn't copy all of these people to this memo, did you?
No, I only copied my boss and also the manager of well interventions, and this is the office for the GSIAP, that is the manager's office for well intervention. He was not the administrator of the contract.
Ignacio Solis's files for the May 3rd memo.
I didn't do it personally. My team reported back to me, and I was told that we looked into our records, we looked into PEP records, and as a result of the adjustments within Pemex starting in 2019, the idea was to consolidate some areas, and this office transferred contracts, records to other areas, and certainly as part of that process of sending and receiving documents, it may have been lost. But whatever this communication said, it is irrelevant for the provider, because what has an impact for the provider is the initiation of the proceeding, and in this case, the notice of the rescission. These are documents that are broadly known to the provider.
Tasio Solis still at Pemex?
I do not know. I don't think so. I think he retired.
What about Mr. Musalem?
I am 100% sure that he's no longer with Pemex.
Access to their files even though they are no longer with Pemex?
Yes, the areas still exist. So we should have access to their documents.
Just a minor clarification, just to save time. Señor Lustano, si le he entendido bien su declaración.
If I understood what you said correctly, is that the author of that memorandum of 2017 with such a complicated acronym, you are identifying that the author of that communication was Epitacio Solis Fuentes. Is that what you have stated? Yes.
Who told you that the May 3rd memo could not be found in the extensive search that was conducted?
The manager with private litigation.
That person have a name?
Yes, Arturo Soto Barrios and his team.
When you spoke to Mr. Sotobarrio, did you make the same comment in terms of the relevance of that document? That you found that it is not relevant?
No. No, I didn't make any comments. Rather, this topic, this explanation that I requested was derived from the arbitration. And I said, hey, what happened with this document? We can't find it anywhere. This was not a request prior to the request, a communication or a comment prior to the request. I said, what happened with this document? Because it is an issue in the arbitration. When you said, hey, explain that document, when you had this conversation.
Was that the conversation you had with Mr. Arturo Sotobarrios? What you just told me?
Fue alrededor.
It was about a week ago when I was reviewing the documents for the hearing, and I saw that this topic, the May 3rd communication may come up.
You had a week ago with him.
Sí.
Yes, about a week when I was preparing for the hearing.
Finally, this memo says, among other things, that's referenced in the May 3rd memo, in addition to proceeding with the notice of the administrative rescission. What were those other things with respect to the 821 contract?
That area, that office that had to do with well intervention commissioned many things. It was not the only contract with the office, and it was not the only service that the contracting office had. It could have been something related to this contract, to a different contract, or some other issue that had to be reviewed together.
I would like to look at C 128. If we could expand the bottom of the CC. You were copied to this memo, correct?
Sí.
Yes.
This memo, if we can go back to it, this memo refers to a meeting that was held on May 16, 2018, correct?
Sí, hace.
Yes, it refers to a meeting in Villahermosa.
And at that meeting, someone from the department within the legal area of Pemex that fits your job description attended. Was that you?
No me acuerdo de haber.
I do not remember having participated, but based on what it says here, someone from my area went.
Was about making a claim against the $41.8 million Dorama bond in May 2018, correct?
Yes, based on what we read in that communication, yes. Once the administrative rescission of a contract is decided, there are some consequences, and one of those consequences is, among others, resulting from the rescission, is to enforce the bonds, in particular because the administrative rescission, being an administrative act, has a presumption of validity. Therefore, PEP, if there is no precautionary measure, may carry out the enforcement of the bond. And if they fail to do so, in our model policies for bonds, we see that the term to claim against that bond would be 10 months as of the breach that led to the rescission. So the claim for that bond was a consequence of the rescission. So much so that from the point of view of our bond policies, we had to respect, we had to observe the term under that bond to present the claim. I do not recall this policy, but our policy model is 10 months from the breach or the rescission. So if you do it after, you may get the reply that the bond does not cover that because it is beyond the term. So whenever we have a rescission, we are careful and the bonds need to be claimed timely.
You're aware at this time the administrative rescission was being challenged before an administrative court, correct?
Today, yes, I am aware of that. But in May 2018, if I go back to May 2018, I do not remember having knowledge about that administrative rescission. And at any rate, the fact that an administrative rescission is challenged does not limit Pemex's right to claim. There should be a precautionary measure by the tribunal ordering Pemex to maintain the status quo, not to enforce the bond, not to carry out any finiquitos, just stay the way you are. And those are precautionary measures that are quite common and that Pemex providers request whenever they appear before a court to question or challenge an act of this nature.
So you're saying at the time you did not know that the administrative rescission was being challenged before an administrative court?
In May 2018, I do not recall whether at that point I knew that there was a case going on, a proceeding going on, because it was not an area of my purview. But let me reiterate to you the fact is irrelevant, whether I knew it or not. The fact that it was challenged or that it was part of a nullity proceeding, that is to say, the debate as to the administrative resolution was properly grounded or not. Because of that, there is no limitation to Pemex's right to enforce the guarantee, the bond.
Going back to an exhibit that we saw before, your name was on an answer that Pemex filed in response to the challenge that was made. So you had knowledge at the time that a challenge was being made to the administrative rescission, correct?
No. This is the document that is replying to a claim that is sent to a court, and it was normal to be authorized as part of the record, and for me, through the record, to authorize a different manager, just in case if it was necessary to do something at one point, or we needed to support the other manager as part of a special situation. Let's say that I am here, and the assistant director has to attend some of my meetings. So this is common practice. And as part of the litigation and also within the offices, we authorize a large number of individuals who are not the ones who necessarily participate in the litigation. In May 2018, just because I was authorized on record to receive notification did not entail that the rescission was being challenged. I could have heard that the rescission was being challenged if the claim is presented. Legal does not present the claim. This is presented by finance. And the bond issuer could have answered, well, I am not paying the bond because the breach, there is a precautionary measure. So I could have learned that. So if the bond issuer had answered that at that point. Mr. President, we are close to an hour and a half, and the witness may need a break, and I think that this is to the benefit of everyone.
Makes follow-up because we are close to half your time, more or less.
Yeah, I understand. There's just a couple of questions left on this. So I want to make sure I understand correctly.
No, Mr. Perlet is recalling us that it was supposed to last for 2 hours, this first tranche of the interrogation, but probably we can cut it short if the two parties agree. But you still have to. No, I meant the break. The break. But you have two short questions to make before we break, and we of course will resume with the cross-examination. So go ahead with those small questions.
So I want to make sure I understood correctly. You stated that Pemex had the right to claim against the Durama bond, the $41.8 million Durama bond, because of an administrative rescission, even though that administrative rescission was being challenged, correct?
Yes. As a matter of fact, this is just a precautionary measure. A precautionary measure would be the one justifying Pemex not to claim against that bond.
Why did Pemex wait 10 months to have this meeting about claiming against the $41.8 million Durama bond?
I do not know.
Please.
I would just like to say I apologize to Mr. Lucenow.
Don't worry.
I'm sorry, and to the tribunal.
Okay. So we break for what, 10 minutes or 15 minutes? 10 minutes. 10 minutes. Okay, 15 minutes. We are short of time because Mr. Lucenow is supposed to be free by 1:30. So, but let's make it 15 minutes. So it's at 9:25. So at 9:40 we'll resume. Okay. Mr. Scheimer, are you ready?
Yes.
Okay. So we resume. You have the floor, please.
So, Mr. Lustinau, I want to refer back again. We had a May 8 memo that we talked extensively about. Pemex would not notify us about the administrative rescission until August 2017. Does that sound correct to you?
It doesn't seem to me that there was a particular date. The official communication did not speak of a specific date for notifying something.
At Exhibit C106, once the technology gets up and running. This is a memo that you were copied to, correct?
Yes.
Do you remember getting this memo?
I don't remember that, but if you give me a moment to read it, then I might remember what it says.
While you're reading the memo, this memo states that notice was sent, or going to be sent, to Finley about the administrative rescission of the 821 contract, correct?
Yes, you can read that in this document.
Why are you copied to this memo if this was not within your department at the Pemex legal department?
Well, as I was saying, it's a common practice to copy all of those who have anything to do with a given issue. And in this case, in August of 2017, I was in charge of handling the civil proceeding. But that did not imply, or doesn't imply, that I had any power, authorization, or involvement in the rescission of a contract on a subject that was so profound commercially and technically as is the drilling of wells.
Without having to go back to your May 8 memo that you wrote, that we went over quite extensively before, what was happening during this time period from May to August, if you remember?
In between from May to August 2017, well, I don't recall. In terms of my duties, I recall that in 2017, I had some 500 matters that I was in charge of with liabilities of 15 billion pesos.
I'd like to talk briefly about an issue called PACMA. I believe you referenced it in your earlier testimony about Finley having multiple breaches under the 821 contract. Is that one of the breaches you're referring to?
Yes.
As I read the documents, this was an issue that was around in 2015, correct?
That may be. I'm not sure if the PACMA was an active issue at that time, but it may well be, because the PACMA is an obligation that is imposed on Pemex providers, where they are to earmark a certain percentage of the amount of the work executed in order to carry out community service work and other addressing social matters.
If this were an important issue to Pemex that justifies an administrative rescission of a contract, why did Pemex wait until August 2017 for an administrative rescission based on this issue?
Well, the thing is, I don't know if the PACMA issue came from 2015. That I don't know. But had that been the case, the contract had provisions such that the breaches would lead to or be the basis for a rescission of the contract.
In paragraph 15 of your first witness statement, you state, and I'm reading in the English version, PEP could not ignore claimant's breaches and continue with the contractual relationship. But it did, right?
No, I don't think that it did.
You say that there were special rules about the scrutiny of several oversight bodies. What are you talking about there?
Well, yes, Pemex is a much overseen entity. There's an internal audit that depends on the board of directors. There is a unit on responsibilities, which is part of the Secretariat of Public Function. There is the high-level audit body of the federal government, which audits the federal budget. And that's what I am referring to, that there is a lot of oversight of Pemex.
I'd like to look at the administrative rescission of the 821 contract. Excuse me, I'm sorry, the unilateral finiquito of the 821 contract. I believe that's R43. Are you familiar with this document?
Not much, but I have no problem going over it. I might have, should there be something to read, or should you have any question about it?
Your name was copied, or included, if you will, in the answer to the challenge with respect to the administrative rescission, correct?
That's right. As part of a regular practice of authorizing the largest possible number of persons, in this case myself as manager.
So I understand this finiquito is a natural consequence of that administrative rescission, correct?
Yes, the finiquito, yes.
Section that talks about Article 6.6.1 of the 821 contract. Scroll down. Let's find it. In this unilateral finiquito, Pemex cites to 6.6.1, and if you look at the bottom paragraph that's cited, and you see certain language that's in bold. Do you agree with me that the 821 contract has a procedure about delayed performance under a work order?
The rescission procedure, or what are you referring to?
I'm referring to clause 6.6.1 of the 821 contract that Pemex references in its finiquito of the 821 contract.
Sí, se establece ahí.
Yes, a contractual penalty is established in case of delays in the work orders. Yes.
And in fact, in this finiquito, Pemex is claiming that Finley owes $262,000 under this particular clause. Correct?
Yes, it says amount to be penalized, 262.
And I want to focus on the bottom paragraph. Do you agree with me that the 821 contract has a provision, as cited in Pemex's unilateral finiquito, about delayed work orders? About delayed performance under a work order.
But what is the question if the contract says that?
Agree with me that the 821 contract, as cited in Pemex's unilateral finiquito of the 821 contract, has a provision regarding delayed performance under a work order.
Yes, it establishes a contractual penalty for delays in carrying out work orders. Nonetheless, in order to know the legal framework in terms of liquidated damages for this contract, you need to look at the actual language of the contract beyond an isolated transcript of a particular clause or a clause of the finiquito. So I think what would actually help us understand the regime of contractual penalties in that contract should be the contract.
So if I understand correctly, it's important to read the entirety of a contract, correct?
That's right.
Did Pemex tell that to the administrative court when it responded to our administrative challenge to the 821 contract administrative rescission?
No, in procedural terms, what is put forth in an answer to the complaint is the response to the nullity arguments being put forth by the claimant or plaintiff. No comments are put forth about how a contract should be interpreted unless the party that is making a claim bases its argument on some improper interpretation of one of the clauses of the contract. Otherwise, there's no debate on that issue.
So is your answer no? Pemex did not tell the administrative court that it needed to read the entirety of the 821 contract when analyzing the administrative rescission?
What Pemex did was respond to the arguments that were the basis of Drake's argument that it should be nullified.
Tendríamos, o sea, para
To be able to answer that question, we'd have to look at the answer brief. And if in some section, in some paragraph, it says, interpret and analyze the contract in its entirety, then that will go forward. But in an answer to a legal action, one doesn't put forth different arguments in isolation. Rather, one answers the arguments that are put forward.
Did Pemex tell the administrative court that it had a penalty clause for delayed performance under a work order, as we are reviewing here in the unilateral finiquito?
I don't recall, that is to say, I don't know whether that was put forth in the answer.
Have you read the 821 contract?
Yes.
So you're aware that the 821 contract has a good faith clause in it, correct?
Yes.
And we're going to pull it up in a second. And while we do, just to refresh, you are aware, as we discussed before, that Clause 15.1R under the 821 contract restricts Pemex from invoking administrative rescission unless and until there are 15 unfulfilled work orders, correct?
Could we go to that clause?
Do you see it at the bottom?
sí la veo.
Yes, I do.
To Clause 3 of good faith. I'll give you a chance to read the first part and we'll move to the next page. Do you believe that Pemex was acting in good faith when it initiated an administrative rescission based on one unfulfilled work order?
Yes. Inasmuch as the non-fulfillment of a work order entails the breach of a substantive obligation under the contract. They were hired to conduct onshore drilling. And what we think is that no drilling works were conducted. And in tandem with that, there were other non-performances. For example, They did not address the orders and requirements issued by the PEP representative. There was also the issue of the PACMA, the issue that they changed their domicile and that they disappeared and that they abandoned the contract. I think that this would mean that Drake violated the principle of good faith. This could then translate into an unnecessary interference with the activities of the other party, or that conduct can also be understood as a lack of cooperation. I think that you could also look at rescission from the viewpoint that there was a breach by Drake of the obligation to act in good faith.
Do you believe it was good faith for Pemex not to impose a penalty under Clause 6.6.1 of the contract, as it says for delayed performance under a work order, but instead proceed to an administrative rescission?
Yes, Pemex, I think, complied with the principle of good faith.
Do you believe it was good faith for Pemex not to tell the administrative court about Clause 15.1R?
The burden of showing the nullity of an administrative act is on the claimant. If the complainant considered that the administrative rescission was illegal because it violated that provision, it should have said so. When Pemex provides an answer, it answers the arguments put forth by the complainant. And I do not see where a violation of the principle of good faith by PEP took place. The one who violated the good faith principle is the provider, in my view, when it brought about all these breaches that could translate into non-cooperation and the non-avoidance of interferences.
Because you were one of the attorneys listed on Pemex's answer in the administrative court, you would recall that Pemex told the administrative court there were two bases for rescinding the contract, Clause 15.1b and 15.1s. Do you remember that?
I do not recall. In my capacity as an authorized attorney, but I recall because I have reviewed the case files. I think that those two conducts were mentioned. When we are trying to summarize things, those two issues are brought up. But if you look at the content of the rescission, you see other grounds according to which the contract was terminated. Not only the non-fulfillment of a work order. To understand the scope that Pemex, of the right that Pemex had to rescind the contract, you have to look at all of the rescission grounds.
You were here during my opening presentation, correct?
That's right.
You remember the portion of the pleading that Pemex submitted to this court that explained in Pemex's words that there were two primary bases for administratively rescinding this contract, correct?
On the basis of my knowledge of the administrative decision is that I'm giving you my answer. I do not recall what you said or what the respondent said in connection with the grounds. I think that this is something that one can easily see when we see the notice for administrative rescission. There you can see what all the grounds are and what the conducts were that were considered to say that PEP had the right to begin the rescission and then to effect the rescission.
Let's look at the third paragraph. These are Pemex's words. Do I understand this correctly when I read that there are two bases for administratively rescinding the 821 contract? One, Work Order 28-2016, and a series of breaches that followed, and two, obligations regarding PACMA. Am I reading that correctly?
You are not reading this correctly. What it says here is that there are two pillars for the rescission, but that does not mean that there weren't other rounds for rescission.
And we follow in the fourth paragraph, first bullet, Pemex tells the court that it was able to administratively rescind the contract based on clause 15.1, it's missing the point 1, B, correct?
I'm not really understanding your question.
In the clause that you just read, Pemex is telling the court that it had a justifiable basis to administratively rescind the 821 contract based on clause 15.1b, correct?
Yes.
And Pemex did not tell the court about clause 15.1r, did it?
The one who should put forth arguments and present reasons for the nullity of an administrative act is the complainant and not the respondent. If Drake considered that the administrative rescission was illegal and it argued an interpretation of R, it should have put that forth, but it didn't. And apart from that, the reason for the rescission was not the noncompliance with a work order. There were other conducts.
Question again, please, sir.
And you believe this was done all in good faith?
Yes, of course. I think Drake was the one that violated the principle of good faith when we look at all of these conducts.
I saw in an opening presentation mention about, I believe it was at some point in the year 2015, that Pemex's board issued a directive. Do you recall seeing that?
Yes, I do recall that a comment was made in that regard. Both parties, I think, commented on that. But if you're going to ask me a specific question about it, I would like to see the document and see what it was said.
Looking for it. Remind me, Pemex's board, I believe it's majority government officials, correct? Or appointed by the government. Correct?
No. In the Pemex law, it specifically establishes that the members of the board are not going to be considered public servants.
Members of the board of The members of the board of Pemex are appointed by the government, correct?
They're not. You have board members appointed by the government, and some of others are independent.
And break down the ratio of how many members fall under each category that you just described.
Are you asking me?
I want you to put some numbers to what you just said.
We have 5 independent board members, and we have the chair of the board, who is the head of the Ministry of Energy, the Secretaría de Energía, and also I think the Ministry of the Treasury has to appoint a representative as well. And there are 2 or 3 other government members as well. I don't remember exactly the breakdown, but you can easily see that if you look at the Pemex law, because it tells us what the makeup of the board of directors is.
So you agree with me that the majority of the board of Pemex is appointed by the government?
No. If are going to talk about this issue, we would have to see what the Pemex law says, apart from what you and I may understand or consider.
We found the portion that I would like to talk about. If you could read paragraph 70 to help refresh your recollection.
¿Me podría poner?
Please, in Spanish. Could we have the Spanish version of this?
Number? R30.
That's good. Were you aware of this? Actually, first, let me just ask you, what is this document?
Es el
This is a directive of the Board of Directors of Pemex, CA 10-2015. It's a resolution.
And what's the importance of this document?
Well, the content, I think, is that what you're referring to, or the importance, in my opinion, of this document is related to its content.
You would agree with me that when the board issues a document like this one, it's important to follow what the board instructs, correct?
Yes, of course. This is the board director, is the highest government body of Pemex, and the resolutions of the board are important.
And did you all follow those instructions in response to this order that was given in February 2015 by the board of directors?
Yes, it also says it instructed the administration to start all acts necessary for the implementation.
I'm sorry, was that a yes?
Es que sí.
Well, there's an approval here for a budget adjustment and also instructions to the administration to initiate all acts to implement those reductions.
So that's a yes. You followed the instructions that the board gave you in this acuerdo of February 2015.
Well, the public servants that need to abide by these instructions, well, they have to abide by these instructions, yes.
Can I have a couple minutes just to review?
Sure. As the time today is somewhat scarce, do you have any questions to interject before you resume?
Later on.
Okay, so let's wait.
Are you aware of any senior level discussions within Pemex about the dispute with Finley?
What dispute? This arbitration, the other civil proceeding, the administrative proceeding?
Any of them?
A high-level official, you're saying? No, not that I recall.
Are you in those meetings often?
What kind of meetings?
Board members.
Well, it's not recurrent. My participation isn't, but when a matter I handle is going to be submitted to the consideration of the board of director, or when I need to provide information to the board in connection with a matter related to litigations, I do participate. For example, in connection with a reparation agreement that has been reached and that is of public interest, or a legal opinion that is issued and that must be made known to the board. Yes, in those cases, I do participate in the board meetings. I think perhaps I participated in 3 or 4 board meetings. It's not very common. When I was appointed, yes, I did participate in the meetings via Teams, and then 2 or 3 more.
So you don't know if the disputes with Finley were raised at a board level, do you?
I would know, because this would be a matter that I would have to submit to the board, because I work in the office related to litigations. If that had been submitted, I would know. But nothing was submitted at a board meeting in connection with the matters related to Drake.
When were you asked to be a witness in this arbitration?
I do not recall, truth be told. I don't know. Perhaps when the evidence preparation stage started, I don't know.
The reason why I ask is there are some issues in dispute in this arbitration that fall outside of your competence. Do you agree with me on that?
Yes, in point of fact, this arbitration is outside my competence. It is within the competence of the Minister of the Economy.
So why you?
I don't know. I assume because of the duties I had back then and the ones that I have now, perhaps because of that.
Thank you, Mr. Lustenow.
Gracias.
Thank you.
You're done?
We'll ask more after. We have some additional once we hear the...
Y, señor Bonfilio, hay ahora...
Mr. Bonfilio, is there going to be any redirect?
Said. I mean, is
I think
the cross-examination completed, or are we holding more questions?
I understand that the first round of cross-examination is finished. Now you have the possibility of a redirect concerning the questions, and the tribunal is waiting for its turn to raise question itself. So now it's redirect.
Si fuera ese el caso, señor presidente.
If that were the case, Mr. President, and thank you for your clarification, we would need a couple of minutes to look at our notes. Yes, of course. Mr. President, can I leave the room for a couple of minutes? Yes. What time is your plane? 5:50, sir. Okay, thank you very much.
Por una cuestión.
I think that he would have to leave here at 2:30 at the latest because of logistics.
Señor presidente, cuando nos lo indiquen, estamos.
Whenever you let us know, we are ready to proceed. Please proceed. Thank you. Mr. Lustonod, we thank you for the time. I will be asking you a series of questions related to the cross-examination led by claimant a couple of minutes ago. Would you please explain, and for the benefit of the tribunal, would you please explain an approximate number of cases that you supervised as a manager of the private law legal department? About 500. I had about 500 cases. Understood. And because of that, you were CC'd in many emails and communications, correct? Yes, very many. Because this is practice in Pemex. You are CC'd in everything. You were asked about Mr. Luis Gomez. You were asked his name, and you said that you do not know him. In general terms, how many employees do Pemex and its subsidiaries have? 110,000 active workers. Are you talking about PEP, the subsidiaries, or altogether? Altogether, 110,000 employees. 110,000. Correct. Claimant asked you whether Pemex is part of the executive, and they asked you repeatedly. And answering these questions, you explained the complexity of Pemex. And for the benefit of everyone here, would you please explain to the tribunal some examples of the business activities conducted by Pemex and its subsidiaries? Certainly, Pemex is a productive company that belongs to the state, and it is peculiar because not all of the oil companies globally perform all of the sector activities. Pemex does. That's why it is so complex, rich, and large. They carry out activities from upstream, midstream, downstream, and that means that it is not only an oil company, quote unquote, but it is also a trader for diesel and fuel in the Mexican market and some of the most attractive markets, such as the Mexican one in the area of fuels and diesel. They also carried out chemical activities. They produce, for example, input for this type of material here. They have also ownership of 7 refineries, soon to be 8. So that also means that they issue or they produce gasoline and diesel products. They have a logistics department. That means that at the same time they have their own transportation, road transportation, pipelines. They provide the input to the refineries, to the industries. So this makes it a very complex and rich company because as opposed to other oil companies in the world, Pemex is in charge of all of the industry activities and all of the elements of the value chain in connection with hydrocarbons. I thank you for that explanation. Let's say that on a daily basis, Pemex and its subsidiaries, such as PEP, carry out a very broad range of contracts with purchasers. Yes, we have 15,000 franchise holders with Pemex. They are the ones that sell the Pemex gasoline. So Pemex also within PEP has the drilling, exploration, logistics related to the rigs, onshore wells, and also the sale of hydrocarbons, crude oil, exploration also. They do have several contracts to carry out exploration activities, to repair wells. PEP is an oil company that, contrary to other oil companies, carry out many of the activities in addition to upstream activities. And for these activities related to the upstreams, do Pemex and its subsidiaries enter into a different range of commercial contracts? Certainly, depending on the needs. I apologize, Mr. Bonfiglio, if you allow me. I think that the members of the tribunal are aware of the broad range of activities that Pemex carries out, which is a well-known company all over the world. I am familiar with it for 30 years, and I think that Mr. Pelé and my colleagues here are aware of the broad range of commercial activities, as well as Mr. Fuentes. Thank you, Mr. President. Moving on to a different question. I would like to show you C-127. I am going to ask my colleagues to show it on the screen. This is the reply presented by Pemex Exploration in the annulment proceeding in 2017. If we scroll down, there is a list of about 20 to 23 attorneys for Pemex. And if we scroll down right there, we have a reference to several emails, 3 email addresses that were not shown to you. My question is, do you recall participating in the annulment proceeding in 2017? No, I did not participate in that one. Could you please explain to the tribunal the purpose of appointing so many individuals, as we see it here, in addition to the attorneys that are defending the case? Well, if at some point attorneys change, there should be other individuals who are authorized, or if at some point one of them cannot carry out a consultation in connection with the record, any person may go. And it is quite regular because there are many litigations and you may be talking to an attorney, let's say in my record that is under my control, there's such a mention. So could you please check that since you're at the court and bring me the right reference, since they're talking about the publication? Yes, and this is what they do. And oftentimes the attorneys are not the ones leading the case, but they can be consulted. Would you please explain to the tribunal whether you were part of this memorial as part of the annulment proceeding in 2017? No, I did not participate in any of this drafting. Agreed. So, claimant asked you about your participation in meetings with members of the Board of Directors, Pemex Board of Directors, and you were also asked whether this arbitration was also mentioned during one of those meetings. Now, litigations in connection with 821, were they relevant to Pemex? Honestly, they were not. Would you please elaborate why they were not, or you do not recall? Well, they were not. In the area of civil litigation, I recall that when we were served notice, it was striking that the contract included an arbitration clause, and they did not resort to that. But I thought, well, they already chose to resort to courts, and we are going to address the claim here at the court level. And I also recall that they also indicated an exorbitant amount, but the amounts do not make a topic more or less relevant, because we are familiar with amounts that are really significant under these contracts, many others, and also as part of litigation. And I didn't think it was relevant because when we studied the initial memorial, the statement of claim, Leonardo Santos' counsel told me that the contract was in force and that there were many other contracts with Pemex, and it had minimum and maximum amounts that work based on service orders, work orders that are being issued as Pemex needs those work orders. And I was being told that we were being accused of not presenting any work orders, so it had to be addressed as any other issue, but we didn't think that the Drake claim had the merits to corner us or to put us in a difficult situation that would turn into a relevant or difficult situation. Thank you. How many civil litigation cases is Pemex currently facing? They have increased, and we have fewer administrative cases. So the civil ones are increasing and the administrative ones are decreasing. There must be around 1,000 cases, including arbitration, civil, and administrative cases. Thank you. We understand that you were not involved directly in defending Pemex exploration and production in 2017 as part of the annulment proceeding, but based on the questions by claimant, would you remind us whether claimants in that annulment case in 2017 alleged that PEP had acted inconsistently with the 15R clause, with clause 15R? No, I do not recall, but based on my reading of the statement of defense, I saw that it was not a document that was never, it was an argument that was never presented, and if it had been presented in the hypothetical world, the rescission would have been declared valid because it had to do with a different breach. Understood. And claimant in that case, in that annulment case, and we understand that it is Drake Finley, at any rate, did they have the burden to claim and show the alleged breach in connection with that grounds under Contract 821? Yes. The procedural rules that govern the administrative proceedings determine that there is the party that is claiming the nullity has the burden of providing all of the evidence. And also we have, in this case, some of the other principles that have to do with the claim do not apply in this case. That is to say, to conclude now with this, that in spite of the fact that the rescission started, the contractor, Drake Finley, had the right to defend themselves, introduce evidence and allegations, arguments, where? As part of the rescission proceeding, certainly. Would you please explain to the tribunal whether PEP was not allowed to ask for the enforcement of the Dorama bond in spite of the fact that in the 2017 annulment proceeding, the nullity of the rescission for Contract 821 was being argued? Yes, they had the power to do so under the Administrative Proceedings Law, whereby the very first articles indicate that administrative acts, once issued, are assumed to be valid and that they are enforceable from the moment they are identified. In particular, one of the effects of this rescission is to enforce the bonds. So in spite of the fact that it was challenged, they had the right to enforce the acts until there was a legal decision against it. And on a daily basis, the bond issuers don't usually comply with the payment of the bond. They are saying, well, there is a precautionary measure, or this is being heard in the case before the court. So usually they don't pay at the first request. We need to initiate a special bond proceeding to force the bond issuer to pay. I thank you for your time, and members of the tribunal, we have no further questions.
Questions. Do you, claimants, have any redirect questions, or you just wait for the tribunal? Because my guess is that probably after the tribunal poses questions, both parties will want to step in, and they are authorized under our last procedural order, and that might be more efficient.
Indeed, we do have questions, but we agree it would be more productive to wait to hear from you all.
Okay.
And then proceed.
Let's now start for the tribunal to ask questions, and I have quite a few, but my colleagues may want to start. Or
no question from me.
I've got a few. Starting with the first one. Yeah. Starting with the first one, Mr. Lustenau. About Pemex's functions. I understand that in the judicial proceedings, there's, like you said, there's 3 levels or 3 sub-proceedings. First, when Pemex or its subsidiary issues a decision, there's a formal opportunity for the contractor to justify or defend itself against the rescission before the Pemex entity. And then afterwards you'll have the recurso de revisión before that very same, or the contractor can go to the tribunal, to the vía tribunal administrativa. Now, is that not sort of an adjudicatory function? I mean, usually if you would have a contractor and a subcontractor, and the contractor fires a subcontractor, you wouldn't have a formal proceeding where a subcontractor can defend himself and then initiate the so-called formal revisión, recurso de revisión. In other words, is the Pemex entity not acting in an adjudicatory fashion?
Disculpen el recurso.
Are you talking about the review proceeding and also in the first instance, what they call the first instance? I wouldn't call it as a separate instance. I would say that it is an opportunity. Yes, an opportunity, but that is a formal opportunity. Let's say it is a pleading that is presented. It goes beyond informal negotiation. It is presented and there is the filing of a record. Yes, it is presented. It says initiation of rescission proceeding. Later, the provider has the right to produce their arguments, evidence, allegations, and that's where we have the first moment. And when the party has the right to be heard, that right is granted, and then we have the review proceeding and the annulment proceeding. They are options. That is to say, the individual may decide whether to resort to the review proceeding or to the administrative proceeding. So there is a right to be heard, you are telling me, in the first phase before the contracting party may resort to a review proceeding or to the administrative proceeding. Yes, because it could be that based on the argument presented by the provider, they could see that the breaches were misrepresented. At paragraph 7 of your first statement, I read it in English, and I apologize, I will read it in English, in Spanish rather. And I also provide legal advice on the legal risks that Pemex may face. And before that, you're saying that you work on arbitral proceedings as well as alternative mechanisms for dispute settlement, as well as coordinating and establishing attention and strategy for those proceedings in which Pemex, EPS, and the subsidiaries are parties to. But I also saw that as part of the transparency proceeding, you were shown C-141, that your entity, the legal office, was contacted to address these requests in connection with transparency. My question is whether, in addition to being contacted as a witness, my question is whether your entity was also contacted in this case to contribute or to provide what you call legal advisory on the legal risks that Pemex may face in connection with this arbitration. Formally, this arbitration is not in charge of Petróleos Mexicanos. I understand that. But there are some issues that may have an impact on Pemex, and they have a certain impact or relevance for Pemex. So I was wondering whether you, or rather your office, the legal office, would have been contacted to provide advice to Pemex on this case. No. We were contacted by the Office of Economy, and to be quite frank, I wouldn't feel able to advise someone on an investment arbitration proceeding. I am not familiar with the proceeding. I am not familiar with the concept under the international agreements. I am more familiar with litigation at the domestic level. At paragraph 7, you also said that you participate
in proceedings.
Sí, arbitrajes.
Sí, perdóneme. Que usted dice más adelante.
You're also saying that you are involved in issues internationally as well as arbitral proceedings. That's why I was asking you whether you were contacted not only in connection with this arbitration, but also you as a person who has the legal knowledge, but also as an advisor to Pemex on any issue that may have an impact on Pemex. No, I wasn't contacted. The arbitration I was referring to are commercial arbitration that have to do with contracts. A question of a technical nature, and I think this would be a question for the experts, but at paragraph 11 of your witness statement, you referred to evidence, supervening evidence. And I wanted to talk to you about supervening evidence under administrative law, because I have a different concept. Supervening evidence is evidence that is discovered later on and that could not be discovered earlier, and that it could be included in the proceeding, or it could be a legal decision that has been issued afterwards and that could be introduced to the record. But according to what I know, you cannot introduce new evidence that has been created, such as a communication, for example, or a communication that is created with the intent of introducing it to the record. What is, in your opinion, supervening evidence? It is evidence that indeed did not exist when the claim arose, and here the inability to introduce it, but the contract was being rescinded. And if in my civil proceeding, the subject matter had to do with breach of the contract by PEP, when I realized that they were going to serve notice on the initiation of that proceeding, just the initiation, I thought it was relevant to say that if the contract was rescinded, they would have only 3 days to serve notice to me so that I could contribute that evidence. But if you're talking about existed, here you're saying existed. What does it mean? That they were not able to find it later before, or that you can write the document, you can write that supervening evidence and say, later on, after the initiation of the proceeding, I am going to create this communication and I am going to introduce it? No, not at all. So it has to be a document that existed before. As I understand it, it was going to be a document derived from the proceeding and also compliance with the contract in force, and it was likely that the contract was going to be rescinded. My intent was to let them know that if that was the case, they needed to send me that to produce it as evidence.
But what I would like to make clear is that there was no fabrication ex professo of the document. It was rather in the face of the situation of the contract. Certain breaches were detected that led to the beginning of this procedure. And I was interested in, well, if it were to culminate with a rescission, that be given to me so as to try to shore up our arguments in the regular proceeding. And had that been done or not, I thought that our legal case was solid. And supervening, why do you call it supervening then? Because I could not produce it, rather it did not exist at the time that we answered the complaint. Thank you. Now, a question related to paragraph 15 of your first statement, and here you say, in the second line, PEP could not ignore claimant's breaches and continue with the contractual relationship since this could be audited and result in a sanction on PEP's employees. My question, you were engaged in your function of providing legal counsel. Now, did you produce a memo or writing in which you notified or informed the respective staff regarding their duty in this regard, that they might well be audited and therefore they had to act in this fashion? No, I didn't write any memo along those lines. Rather, the areas that administer the contracts are the ones that are more careful about such responsibilities on an ongoing basis, because at the end of the day, those are the areas that are audited. The ones that handle budgets, that carry out contracts, are the ones that are most audited. So, had there been an audit of that contract the next day, and I didn't say this in any memorandum, but what I said in my statement is that it would have been very questionable in the face of this series of breaches and in the face of this abandonment of the contract, that they had not taken the measures which should have been taken as per the contract. Now, a question, and this might be a mere misunderstanding on my part, in paragraph 16 of your statement, you say, and this means that I did not have access to the file, nor was I aware of the details of this lawsuit. And I simply wanted to know, because in paragraph 13, you say that it is normal to request access to the documents related to the contract. So my question is, do you have access to the record or do you not? Or did you have it at that time or did you not? What I'm referring to in paragraph 13 is that the legal area does not administer contracts. So when a given lawsuit or dispute or notice comes in, we don't have the information. We have to revert to those areas of Pemex that perform those functions. And access to the administrative matter, well, I never had that because it wasn't within my purview. It wasn't a lawsuit that I was handling. As you see, I was handling any number of proceedings so as to I had so many, I wasn't going to go and ask for information about something that wasn't under my responsibility. One thing is to have possession, to have them in your computer, to be able to access those files quickly because they're in your office or on your floor. But what you're saying here is that you did not have access.
File. Lo que para mí es otra cosa, que usted.
Now, for me, that's something else, that you have the possibility of obtaining those documents should you need them. And in that case, you've answered positively, affirmatively, that even if you didn't have access to the documents because they weren't in your office, they were in another department, you were able to gain access to those documents.
Del juicio contencioso administrativo.
Correcto, está en su alcance.
Está en mi posibilidad, pero no sin.
Sorry, wrong channel. Interpreter apologizes. In other words, they were available to you. They were available to me, but I could not make any decision regarding the strategy in that lawsuit or the scope of it or how it's to be handled because, quite simply, it wasn't under my purview. Now, as my last question, and when it comes down to it, it's more for the experts, but as you make reference to the topic, and I now make reference to paragraph 34 of your second statement, and also paragraph 20 of your first. We're talking about the ex parte contacts. You say that well, let me see the phrase that you use at 34 in your second statement. And I'd like to know if I understand this clearly and if I'm not affected by any confusion. What you say here in the last sentence is that the right of an attorney to meet with a judge to present his case is a right that all parties involved in lawsuits have, and it's not limited to Pemex. Anyone who goes to court will be received and heard. Now here you make reference to the right to be, well, what you mentioned earlier in the administrative proceeding before Pemex, the right to be heard, where the other party is present. Or in this paragraph 34, are you talking about ex parte contacts? No, I'm referring to ex parte contacts. If you're party to litigation, then you can take your lawyer, your advisor, your representatives to a meeting with any official. And on that occasion, can one also discuss the merits of the case based on your knowledge of the practice? Is that generally done? Does one generally talk about why one is right and why the other party is not right? It's not so much a dialogue. It's more a presentation by the party that seeks the appointment. The idea is to update the judge as to where the matter stands, the one you're going to discuss, and to try to summarize the dispute in very precise terms, and also what your position is, what your arguments are. And this is done in Mexico by all legal offices. It's very common for parties to go to the court, and you see that the other party is discussing the judge, and you're going to say, well, I want to talk with him as well. But it's not a back and forth. To be very frank, it seems to me, and I'm Peruvian, and that might exist in Peru. I don't think so, but I think it's a very unusual practice, to be quite modest. Now, I see that in paragraph 5 of your first statement, you said that you had read the expert reports of Mr. Zamesquita and Zamora, correct? The experts who are here. So have you read those expert reports? The experts report, yes. And you see that their opinion is different than yours. That if that practice exists, it's definitely unusual, or perhaps it could be characterized as unethical conduct. I mention it because you say that all law firms in Mexico engage in this practice. It seems inconsistent if there's an expert who says that it's a practice which could be problematic or even prohibited from the standpoint of professional ethics. That's a question that should be put to the experts. Nonetheless, as I'm familiar with their histories, it wouldn't surprise me if they had at some time gone to a court, to a judge, to put forward such an argument. It would seem in this fashion. I think it would be quite unusual if they had never had such ex parte communication.
I changed my mind. Just one question on the visits to the judges. I am neither Mexican nor Peruvian, but I am French, and honestly, for me, it's terribly shocking. But we are not here to criticize the state behaviors. But when you do that, have you the other party is aware? Does it know what has been exposed to the judge? And if not, what about the principe du contradictoire? I don't know how you say it in English. the contradictory principle, which I think is fundamental in any kind of flow. Just to have your opinion, I'm not sure it's that crucial for our discussion, but I am so astonished of this practice, I must say.
Yes. To answer your question, you don't find out naturally that the other party went to speak with the judge. You might find out by chance, and that one places in jeopardy the principle of contradiction in a proceeding. Well, I think that part is taken care of insofar as the judges or the clerks, well, what they always say is that in the record? Is that in the record, attorney? So you're not going to go and make an ex parte argument in order to add new things that are not already in the record. Rather, mindful of the workload in the courts, what is sought is for your matter to not fall through the cracks, given the large number of matters, and when your file goes to the clerk or to the judge, that they can have fresh in their mind what the issues are. And now, finally, those ex parte arguments have no validity or no echo in the judge if they're not in the file, if they're not in some evidence or some document, or some element that's been introduced into the record. I think the practice answers to that. It's a judicial system that has a huge workload, which often generates concern in litigants who want to have the opportunity to put forth their arguments in a synthetic fashion and to make sure that the person who's going to resolve the matter is updated as to what it's about. Thank you very much, Mr. Lustano. I have a few questions. First, I've heard you use the expression alegato de oreja 3 times. This must be a term coined in Mexico. Yes, it is a term that refers to such a conversation, this communication. So this is like a Mexican contribution to legal terminology. I wasn't familiar with it. I have questions about several areas beginning at the end, and the end would be the quantum of the contractual penalty for administrative rescission that PEP is seeking to apply, charging it to the Dorama bond. And let me put a preamble to you before asking the question. As you said, to analyze these things, the best thing is to look to the contract. Plus, you've said that you're quite familiar with Contract 821. So I'm going to read 2 sections of Clause 663 and then Section H of Clause 10. In my view, they are somewhat related. So if we look at Contract 821 in Annex C34, the first document on contractual penalty due to administrative rescission of the contract, says that in the event that, in keeping with what is stipulated in Clause 15, PEP determines administrative rescission of the contract due to breach by the contractor, PEP shall apply thereto a contractual penalty consisting of the equivalent, an amount equivalent to the amount of breach which, according to the contract, should be current as of the date on which PEP communicates to the contract administrative rescission of the contract. Now, if I were to read this alone, I would tend to think that when there is a rescission, the contractual penalty is equivalent, in this case, to 41 million of the Dorama bond. Automatically, this, according to a little reading of that first paragraph. But if I then look at the clause concerning the bond, which is clause 10, and I'm sorry, I don't know if someone could be so kind as to yes, excuse me. Let's look at clause 6 first, so we can repeat what I just said so quickly because I had it right in front of me. I have read from clause 663. What I've read is that first paragraph, which suggests on a first reading that if there is an administrative rescission, in principle, the contractual penalty due to rescission is equal to the amount of the guarantee, in this case, the Dorama bond, $41 million. But if we look at clause 10, and in particular 10.1h, or 10.1, performance bond, in order to guarantee performance of the obligations and so on and so forth. And then it says the contractor expressly states. And now if we could go to H. Its agreement for the surety to pay PEP the maximum limit guaranteed in the event that the works that are the subject matter of this contract are not useful or usable by PEP. With which I tend to think that what this clause says is that in order for the bond to be executed, PEP has to show harm, that the contract done by the contractor, that the work done by the contractor hasn't been useful, and therefore the performance bond is executed. But the execution thereof has to be causal, or it has to be a ground. PEP has to show that it suffered harm as a result of the conduct by the contractor, which has given rise to the rescission that has an amount similar to that of the bond. Otherwise, it would be a bit exorbitant if there's a rescission because of action by the contractor that has caused limited harm. Then I'm thinking about the PACMA obligations, relatively low amounts, and these were totaling a few $1 million, but then you impose a contractual penalty of $41 million. That seems excessive. So herein comes my first question. In your view, based on the contract and based on PEP's experience, the amount of the contractual penalty in the case of rescission, is it always the amount of the performance bond, or is there a certain margin of discretion in PEP when it comes to applying that administrative power that the administrative legislation provides for and that is then set forth in the contracts? Yes, from my point of view, once the rescission goes forward, the provider becomes the creditor of the amount of the bond. And PEP is not obligated to show that it suffered a negative impact. In Mexican law, one distinguishes between a contractual penalty and damages, such that when you agree on such a clause, you cannot even claim damages. So that contractual penalty, which the provider is familiar with from the outset, from when he signs the contract, or from when it signs the contract, is known. And it's not only subject matter in this contract. In all the contracts, it's established that if there is administrative rescission, the contracts under this legal regime, that if there is administrative rescission, then they will be creditors of the contractual penalty, which is covered by the performance bond. And in this case, it's 10% of the contract amount. And now what is that answer to? The breach by the provider, it's not that there's been a violation of a PACMA obligation, building a school, a road, what have you. Rather, what is affected when a Pemex contract is breached, particularly PEP contracts, is the impossibility of the oil company to produce crude oil. And that is why the equivalent of 10% of the contract is established, because you are not able to perform your principal function, which is to produce. Now, perhaps if we were to say there's not going to be a rated or percentage contractual penalty, and we are going to claim damages instead, consequential damages, then perhaps that amount would be greater, plus consequential damages and such, then that might be greater than the 10% of the contract amount. So I think what is sought is to have objective, reasonable parameters vis-a-vis administrative rescission, which for contracts such as these, administrative rescission is the maximum sanction that can be imposed. Very well. So as to calibrate the rigor of that rated contractual penalty and look at it in relation to the bond, well, let me share a thought. We have seen before that the two essential grounds invoked by PEP to rescind the contract were first, a non-performance of Work Order 028-2016, and then failure to carry out the PACMA obligations. And after that, there was also failure of notice, very much tied to the first breach. Now, so in your view, according to the contract, could PEP have rescinded the contract if only one of those grounds were present? Or do both have to be there? There are two. So my question is, if we can go back to the or that we discussed yesterday, does it suffice for one of the grounds to be present, or did it have to be both? And PEP could have received this simply because the contractor did not, for example, build a dining hall. From my point of view, breach of one suffices. In terms of the contract, if you review all the grounds for rescission, there is a generic one, which says when the provider breaches the terms and conditions of this contract. And that is a risk that the provider needs to weigh when signing a contract of this sort. And to the extent that, taking the case of the rescission, that this answers to a power that is in the contract, but that derives from the jus imperium that states enjoy, which translates into the unilateral power of rescission, which is presumed valid and which is directly enforceable, even if called into question. There's no doubt but that PEP is exercising public powers. And you have spoken of the very wide range of activities carried out by Pemex in the world of oil, but in this specific case, when it comes down to it, what it is doing is exercising a power of public law, of administrative law, rescinding the contract, and due to some breaches whose harm it doesn't have to show, it imposes as a penalty the total amount. And so if you have I give you work orders for totaling $48 million, but I'm going to impose a penalty of $41 million. This is a power of the Mexican state which applies with full rigor to the contractor, or is that not so? I don't see it in that way, because the bond is thought of in light of the total amount of the contract. And in response to the rescission, well, PEP has its productive capacity diminished because producer X, who was going to carry out a certain activity that was going to generate profitability for PEP, was no longer going to do it. So it doesn't seem to me so strict or an issue of use imperium. I think it's a commercial, a contractual issue because, as we've just read, this whole dialogue or those questions, which are quite keen, derive from the language of the contract itself. And so there's a weighing of risks as to whether a provider, there have been many cases that that say your contract is very one-sided, or no one is going to finance this contract, or I'm not able to perform on this contract. Well, then don't sign. What happened here is that they did sign, and in that signed contracts, under the list of contractual penalties, it is said that if the rescission happens, then one has to put up the maximum amount, which is the $41 million in the bond. We've talked about the PACMA obligations, but in contracts signed by other companies other than PEP, does Mexican legislation require that the contracting party impose on the contractor obligations such as the PACMA obligations to carry out works to benefit communities? Or is this an aspect of the legislation that applies only to PEP, this burden on the contractor of carrying out certain works so as to benefit the communities in which they operate? I don't know about other instrumentalities, but in PEP and in industrial processing and logistics, generally, when the works in the oil sector generally have an impact on the communities where they unfold. So they could be works or projects that generate pollutants that are going to disturb the environment or the territorial configuration. So what is sought with the PACMA clauses is not so much a paternalistic gift or an unjustified burden on the provider. Rather, it is a means by which it is sought, we seek as the oil industry to compensate for the harm or the negative impact that that will occur in a given community. And this is a practice of all oil companies around the world. In the newspapers, we see that the companies themselves, oil companies, when they make an investment for medicine or to support the community. Yes, but in this case, what is imposed by law, it is imposed by law, and it suggests that it's a case of jus imperium. That is to say, PEP is requiring that contractors do something to benefit a general public interest, not specifically of PEP, because PEP is a public company and requires this. So we're not in pure private law, rather we're in the realm of administrative law. And PEP there is acting as a public law entity subject to the obligations imposed on it by law, correct?
When it comes to the PACMA obligations, I don't see it that way. But when it comes to the Administrative Act, yes. Rescission is an administrative act. I fully agree with that. But in the case of the PACMA obligations, that is not the case. PEP could have said, okay, we will no longer impose PACMA obligations, and this would not change in the nature of the contract with Pemex. PACMA obligations imposed by PEP, it wasn't because PEP was obligated by law to impose those obligations, right? Not so much the law. This had to do with internal provisions in Pemex. Pemex wanted to protect these things, and it incorporated obligations such as this. Okay, so this is part of the social corporate responsibility that PEP has. It's not a legal imposition. That is right. Okay, let's continue talking about the quantum of, or the amount of the bond. Out of 663, we get that the contractual penalty should be the same as the Dorama bond amount because in August 2017, when the contract was rescinded, I think we have it here somewhere, it is R42, but I don't think it's necessary for us to look at it. But why are we saying that the penalty for rescission is going to be established in the finiquito? We knew under the contract what the rescission penalty was going to be. So why is it that we put off until the finiquito the setting of the contractual penalty for rescission? This was already provided for in the contract. This would suggest to me that perhaps the amount of the contractual penalty had to be changed because of some factor, and then the final amount would be established in the finiquito. It wasn't established a priori under the contract. Traditionally, the only issues addressed in a rescission is the breach of the contract. The contract provides that as a consequence of a rescission, a finiquito will be issued. We address the accounts and the numbers at the finiquito. The correct document to talk about numbers, to talk about figures, is the finiquito, because it is the penalty, if you will. So, what we deal with in the rescission is whether there was a breach of the contract or not. And then there is another stage, which is the consequence of the rescission or of the organic termination of the contract in accordance with its own terms, because the finiquito will take place whether the contract ends in accordance with its own terms or it is terminated in an early manner. So the finiquito always takes place, and at the finiquito is where we address the issue of quantum, numbers. That is when we get the amount that we owe. Yes, I understand. I understand that in the finiquito you have to include the amount of the contract penalty. But is it the decision made in connection with the amount, or the amount was already established in the contract? Perhaps in the rescission document of August 2017, perhaps it could have included that. But let's look at C-128 now. And this is the meeting in the city of Villahermosa of May 2018. And you were CC'd here, but you said that you didn't recall having participated in this meeting, but somebody from your team maybe did. If I read the second paragraph of this document correctly, it says, after the meeting of 16 May 2018 in the city of Villahermosa, where personnel of the Mercantile and Civil Contentious Legal Management participated, it is informed that the amount to be claimed is $41 million. And my question is, are we just saying that as a consequence of the contract, this is the amount, or are we saying that the contract penalty will be $41 million? Was this a mechanical consequence of 663, or was this the result of a decision made by a large number of representatives of PEB when they met in Villahermosa. I don't know what else they met there for, but this was also a massive meeting of people to establish the amount of the contractual penalty because of the rescission. So it appears that this was the purpose of the meeting, because if the amount of the contractual penalty was set in the contract, perhaps this meeting should not have taken place. This meeting was not held to define the amount of the contractual penalty. This meeting of all of these people from all these different offices was held because during the process of an enforcement of a guarantee, you have a number of people from different offices that are involved. This is not to define the amount of a contract penalty, because this was defined, I think, in the contract. So the administrator, that is to say PEP, is in charge of the contract and of the bond. Then the administration office has to talk to procurement, because procurement is related to contracts as well. And it is the one that keeps all the original contracts, right? For example, the original of the contract that was signed and the original bond that was signed. So the administration should talk to procurement for it to begin the claim. And the claim is not in the hands of procurement, or it is not in the hands of administrator. It comes to another office, which is the Office of Insurance and Bonds. So Insurance and Bonds submits the claim. If the bonding company rejects the claim, and this is very common, it happens all the time, this goes to a different department, which is legal. So you said that this was a meeting of a large number of representatives of PEP. Yes, that's true. This is an ancillary matter. It is a guarantee, but we have 4 different offices that are involved here. That is the reason, sir, why we have a meeting with representatives from so many offices. This is not a meeting of cardinals, but it is a meeting of PEP officials. But at this meeting, was there anything else that was dealt with? Did they have anything else in their agenda? Well, a number of items are included in these agendas. PEP has a number of contracts. So this meeting is held to look at the status of the enforcement of the guarantees. And the auditors look at this and they said, okay, and the letter of credit lapsed, or the bond debt lapsed. And this would entail that there is a financial damage to the official. So all of these meetings are held to follow up on the collections of the multiple guarantees, including the contracts entered into by PEP. Let us look at R42. R42 has to do with rescission. And let us look at page 44. Let us see if you understand what I have doubts about in connection with 663. And where it says third here, it says PEP will establish in the finiquito that will be drawn up the issues related to 663. This is not very well drafted, but this may suggest that the amount of the contract penalty was not very clear, or that PEP had some discretion when setting it. If 663 would be as clear as to say that the contract penalty was exactly the amount of the drama bond, then things would be much clearer. Isn't there some doubt when you read this paragraph of the rescission dated 28 August 2017, in the sense that the amount of the contract penalty was not fully clear? You didn't really have to only go to 663. You had some discretion, right, to set the amount. I don't see it that way. I have participated in a number of rescissions because of the lawsuits that were brought about. Well, when we prepare the finiquitos, the documents must be clean. In the rescission document, we only deal with the breach of the contract, and in the finiquito, we deal with figures. These are two different documents that must be produced no matter what. And the courts have said that the finiquito is an obligation that the company has. The company must issue a finiquito. So I think in order to do things in an orderly fashion, we have one document that deals with breaches, and we have a different document that deals with figures. So it says here that the amount of the penalty will be set in the finiquito. But this does not mean that this limits or leaves aside the penalty clause. Okay, let us leave this issue and let us look at another document that we have debated, the parties have debated, which is 103, which is a memo by you of 8 May 2017. And you made reference to this document in your own witness statement. And as I said before, in connection with what the claimants said, you have clarified to us that this document of 3 May 2017 had been issued by Mr. Epitafio Solis Fuentes. He was an engineer. And we talked about PEP, DG, SSE, GSIAP. Yesterday, and this is a parenthetical, I was saying that the tribunal was missing an organization chart of all of the investment companies. I think it would be useful for me to have a PEP organization chart. Both parties have included in their dramatis personae an indication of the main individuals and companies that are involved in this case. But I think we need an organization chart with a number of arrows and that include reporting lines and who reported to who was the boss of Epitafio Solis, who reported to him, etc. Before asking the question, I just wanted to share with you something for informational purposes only. On 8 May 2017, you sent this to Mr. Arturo Alfredo Musalem Solis, and you say that he is the person replacing the manager for contracts for exploitation and perforation service and drilling services. So Mr. Gomez was the regular person here. Mr. Gomez worked with Pemex Exploración y Producción. This office had to do with a different department of Petróleos Mexicanos, which is called the Operational Directorate for Supply and Procurement. It says here that Mr. Solis was replacing someone else. This meant that there was no regular regular manager. Oh, okay, so he was an acting manager. Yes, he was an assistant manager in charge of the manager's office. Okay, so I need an organization in charge of who is who at PEP. That would be very useful. All right, let us now deal with the matter at hand. You have said that in this memo you are not providing any instructions to Mr. Musalem. But if we read the first paragraph, we seem to deduce that not you, but Mr. Solis had issued an order to Mr. Musalem for the rescission of the contract. Well, to provide a notice of the commencement of the rescission process. But it says things by means of which, amongst other things, you were requested to proceed to notify the start of the administrative rescission. Here it says notify. They're talking about a notice to the contractor, right? Yes. And this is what happened on 1st July of that year, right? I do not remember when the proceeding started. Well, it was 1st July. This is what the file says. This memo is dated 8 May. And the one from Mr. Epitafio Solis is dated 3 May. So if you read this, you say on 3 May, Mr. Solis told Mr. Musalem to provide notice of the start of the administrative rescission contract, number 821. And then we see that that notice was only given in July. Why is it that this delay took place? Do you know? I can speculate, if you wish, to see whether this can be a truthful scenario. When we have arbitrations, investment arbitrations of this nature or similar to it, we always see that the state company official works together with a private contractor. They're usually engaged in good relationships. There's a cooperation that usually it is provided in the contract. And, of course, there is abidance by the law, but there is not an excessive rigor. There is a situation where there is collaboration or cooperation. But in other arbitrations, I've seen that the state company responsible for the contract was not willing to comply with external political instructions that came to it, and that the manager of that contract thought that that instruction was excessive or complicated. So when you have a number of years of cooperation between a public official from a state company and a private contractor, some links are established, perhaps not friendship, but of cooperation. So it's difficult for the public official to make certain decisions and that the public official deems unjust. So Mr. Musalem was told to start the proceeding, but then the commencement of the rescission proceedings, that document was signed by Mr. Gomez. Perhaps we could look at the document that commenced this rescission, but I think that was not signed by Mr. Musalem. So, couldn't this delay show a certain reticence on the part of the public officials? There were comings and goings, and then at the end they said, okay, there's an order, this must be rescinded, and this took place on July 1st. I do not see it that way, sir. Sir. I think this period of May, June, July, well, because of the pace things have in Pemex, I don't think that this period of time meant that there was a significant delay to make your scenario possible. I don't think there was any instruction of any kind from the board of directors or from anyone that indicated that this contract had to be rescinded. The administrator of the contract, because there were a number of breaches, decided that this rescission proceeding had to be commenced. More than a bond of friendship or of affection between the PEP official that administered the contract and the contractor, what I see is that they were not getting the communications. They had changed their domicile. We couldn't really send communications to them, and they did not abide by the notes in their work log. So the administrator of the contract had seen that the company had abandoned the contract. In the last paragraph of this memo, you remind them that they were granting 3 days to offer the relevant evidence until the civil procedure. And Mr. Musalen could not comply with this very short period of time that you were imposing on him. So from the time where the notice of the start of the administrative decision until July, perhaps this had to do with the fact that you weren't able to locate the contractor and to provide due notice to it? Well, in this memo, I'm not saying, okay, you need to rescind and then you have to do this in 3 days. No. What I'm saying is, okay, rescind, and if you decide to rescind, please send this to me immediately because I have 3 days to do all this. What this memo suggests is that not you, but Mr. Solis provided an order to Mr. Musalen to rescind, and that order was issued on 3 May, right? Yes. However, this all took place in July. There's something that I don't really understand. Well, perhaps you did say that PEP took 3 months to find a way to provide due notice to the contractor. Yes, and also this has to do with the preparation of the documents. You have to prepare the documents that you're going to use to provide notice to the supplier. And during that period of time, there can be comings and goings that may mean that a period of time of 2 months may elapse. Actually, 3 months, right? May, June, July, right? Well, maybe you're right. I don't know. I think my questions are quite long. We have been sitting for 2 hours, so the stenographers are asking for a short break. I'm concerned about your flight. We're going to take then a break for 15 minutes, and we're going to resume at 12:10 with more questions. Thank you, Mr. President.
Are we ready?
Sí, señor presidente. Gracias.
Bueno, pues muchas gracias por su paciencia, señor Lozano.
I thank you for your patience. We are closer to the end. We have fewer questions, and now we go back in reverse order to the famous work order 28/2016, in connection with which you won't be able to say much because you were not involved, as you mentioned. But I wanted to take a look at R41. Because in bold it says date and initiation of the drilling November 17th, 2016. So 28/16 of November was providing for the initiation of drilling. I do not know much about the oil industry. Said that that's when you started to drill the area on that date, December 17th, 2016. And also in a different document and on the record, we see that the authorization request by PEP and Hydrocarbon Office to be able to drill did not occur until June 5th, 2018. So till then, PEP was not authorized to drill. So, and when we look at the document initiating the administrative record for rescission, and I would like for someone to show it, C-104, and we look at page 14, there we see in the third paragraph, and this is, if I don't read incorrectly, there was a group of officials from PEP that went to the drill head, or Coapechaga 1240, that was the initiation of the drilling, and there we see that they attended, but it did not take place because the because the grantee was there. I mean, the grantor was there, but the grantee was not there. So everything was ready for the wedding, but the bride did not show up, as we say it in Spain. So those who were physically present at Coapechaga 1240, they were all aware that the drilling, at any rate, could not be initiated because there was no permit by the Hydrocarbons Office. That understanding of mine, is it absurd or does it make sense? So that is, they went there for drilling, but the contractor did not go, but they knew that it couldn't take place because there was no authorization from the Hydrocarbons Office. Rather, there is a program then that was 2015, 2016. There was a new situation as to the operation of the industry. PEP was the holder before the 2013 reform, was the owner of all of the activity, and physically it was possible to drill a well without authorization by the National Hydrocarbons Commission. That's the way it was done in several locations. There is no issuance of an authorization as such, but the drill is being drilled. The well is being drilled, and it is stated that there is no permit, but it is cured upon issuance. And the fact that the provider did not have any permit does not have any consequence. Rather, a well is drilled without authorization, and there is mention of the owner of the field or the person that has a legal title to extract the resources from the field. In this case, PEP has an assignment title to be able to exploit that field. Therefore, if the regulator, that is to say CNH, had estimated that a well was drilled without authorization, the party that will be penalized is PEP, not the subcontractor or the provider. And it is feasible from the operational point of view to drill a well even when there is no authorization, because you have an yearly program of operations, you have a production goal, and the bureaucratic paperwork that you may need could easily be cured or obtained later on. I have a question. What is the instrument that provides for what you just said? That would be the hydrocarbons law. So I see that this meeting at the wellhead in Coapechaga allows for several alternative interpretations. One, the interpretation of claimants that have not indicated it in that fashion, but that would be what we in Spain would call a representation, something that the officials went there, but they knew it was not possible to do because there was no authorization, but it was done. And in Spain, this would be a pantomime, and this would be like a scheme to prove non-compliance by the service provider. And there is a different interpretation, the one that you just offered. Even if PEP was not aware that the new rule that had been enacted required that prior to drilling, this was before the National Hydrocarbons Commission, that there had to be an authorization, or they were aware of the need for an authorization, but they were willing to be responsible for the administrative sanctions that there could be for drilling a well without authorization. So I think that this is all of the range of possible options for what happened on that date in December. Yes. And also because the contract administrator is concerned about production in terms of accountability. How much are you producing? Therefore, the lack of a permit can be easily cured later on. And the lack of a permit at any rate would entail as a consequence a sanction against PEP rather than against the provider, who in terms of profitability and also thinking about profitability may be more profitable to produce, to put that well into operation, to sell the product and later on pay a sanction to the regulator, if you look at this from the profitability point of view. Yes, but in your interpretation, what would be the logic for PEP that had suspended for 300 days any work orders to contractors for drilling? All of a sudden, in November 2016, they are in a hurry to be able to attain production at this well that in particular was not producing. So what would be the logic to be in such a hurry for the contractor to drill a well that had not been originally assigned to them, it had been assigned to a different company to weather for. It was said yesterday, but what would be the hurry to do so when the price of oil was still low and the government of Mexico and Pemex had decided that Chincotepec was an area where it didn't make much sense to continue to extract oil. I think that here you are referring to different topics. I think that the provider was never added a well that was beyond the scope of its contract. You also said that there was a suspension of work orders. I would like to clarify that idea of suspension. The contract does not provide for any suspension of work orders. Rather, there is a provision of contract suspension, but nothing like that happened here. This was a contract with maximum and minimum amounts that worked based on work orders. So the way the contract is structured, and during the contract, PEP could present work orders, and the contractor had to comply. But I never see throughout the life of the contract that there was an obligation for PEP to issue work orders at a specific point in time. I do not see that PEP had the obligation to issue work orders continuously. As a matter of fact, if we look at the suspension clause under the contract, it says that the period in between the issuance of a work order and the next one will not be considered a suspension. What does it mean? That from the time the contract was signed, the parties provided for a period of time without the issuance of a work order. But the provider was compelled to be ready whenever a work order was issued. Indeed, you read my thinking, my mind, because my last question was going to be about the contract provisions and work suspension, as well as the differentiation between suspension under the contract and suspension of work orders that we could call, in between inverted commas, de facto suspensions. So in the contract, some aspects were striking. You mentioned some of them. So if we could look at C34, clause 17, I think it refers to 804 there. Clause 17. So the fourth paragraph of that clause 17 says that PEP may recognize at special request by the contractor the suspension of the work as indicated below. So the suspension could be requested by the contractor, but PEP had to recognize it. So it was a right that PEP had to grant that request or not, presented by the contractor. I see that here there are two contract rights, one by the provider to request the suspension and the other one by PEP to refer to that suspension due to a fortuitous event or force majeure or due to causes attributable to PEP. I think it is both ways. You have the right to ask for it, and I have the right, given the circumstances, to make a decision. In this case, there was never a suspension request by the provider. Indeed, I was referring to the wrong citation, but now going back to my question, if I understand this contract properly and also the previous contracts, as you mentioned, PEP was not bound, except for the minimum of the contract, to, or compelled to present work orders. And then the contracts also have an explicit clause that provides for the time in between work orders, and that time will not be considered a suspension, correct? Yes. My question now is, wasn't there a loophole under the contract that allowed PEP to decree suspensions without calling them as such? I'm not going to give you a work order during 300 days. Under the contract, this is not a suspension, but from the practical point of view, it is a suspension because the contract is suspended. So, wasn't it an exorbitant number, the one provided for under the contract, the period during which Pemex could suspend the contract de facto, but not, and provide no income to the party? What I see here, and it is quite common in this type of contract with Pemex, that whenever you have a minimum and a maximum amount, this is the way it works. You need a work order so that the service is required whenever it is needed. The fact that it was considered an exorbitant power under the contract I wouldn't say that based on the decisions to be made by the provider whenever they have to consider the signing of a contract, I would say that this is some weighing to be done by the party. This is not a take or pay contract or a lease contract whereby you need to pay whether you use the service or not. This was not that type of contract. This worked on work orders. And that indeed implied that the provider could not receive revenues during a specific amount of time. That also implied that the provider would not have to incur into expenses, and that the equipment or the capabilities they had could be made available to any other provider as long as there was no outstanding work order by Pemex.
They're not. Well, this period in which there are no work orders issued, I don't think it's a special clause that implies that PEP can unilaterally impose its will. Rather, it's a situation that comes up because of the there not being a need for work. And, excuse me for interrupting you, but it seems to me that during this period, with those crude prices, well, it seems to me that for any oil company, it was reasonable to not be engaging in activities for extraction. In all industries, in all businesses, when the price is low, we see this in the steel industry and the minerals industry. When the price is low, the reality is that businesses try to contain themselves and to contain their expenditures. And when prices are high, they begin to produce so as to be able to sell. It doesn't seem to me that this makes the non-issuing of work orders a special power. I think it answers to the market. I'm sorry if I didn't express myself well. I have seen that there is an express power in the contract for PEP, as a matter of its own interest, to suspend the contract, and that is provided for at Clause 17. The thing is that Clause 17 has a subsection 1, I don't know if we could show that, that says non-recoverable costs. Said if PEP suspends, if IPEP suspend the contract, then the contractor can get non-recoverable costs. So how would PEP pay the non-recoverable costs to the contractor? If I don't officially declare the suspension of the contract, but rather all I do is I simply don't send work orders. Is there no official invoking of Clause 17, which doesn't give rise to the payment of non-recoverable costs, the right that the contract gives the contractor when there's a suspension decreed by PEP, but then I don't decree anything, but de facto the contract is suspended, and with the contractor having no right to collect anything? That's where I see, well, maybe it's not a special power. The suspension could be a fully legitimate power. But what I see in the contract is that where it establishes that provision, the period between work orders is not, when that's not considered a suspension, it's an invitation to to possible fraudulent conduct. That is to say, carrying out a suspension without the contractual regime having any provision for such suspensions. That's what seems to me. What seems to me that provision lends itself to abuse. That is to say, where there's no suspension of the contract between work orders. And that could make sense if the orders were monthly. They would be very close to one another, and it would just be a question of days. But if there's 300 days that go by from one order to the next, then that smells a lot like a de facto suspension. Don't you think? Seeing as you see it with malice, it could seem so. But in addition, in the realm of hypotheticals and constructing hypotheses, there was a lot of time left in the contract, and during the time remaining, sufficient work orders could have been issued in order to cover the minimum amount. That didn't happen because, as we've seen, the contract was rescinded. And there one would be complying with the contractual amount. So I don't think that there would be, that the provider would be able to have a complaint, oh, you didn't issue any work orders. But there are two different things. One is complying with the minimum. That's that's a judgment that adds up. And the other is, what about the periods between work orders when they were quite long? And more than just a technical period. The claimants have said that there were periods of up to 300 days from one order to the next. And then you have the situation, that's very unfavorable for the contractor if PEP has not invoked Clause 17, but de facto, by not issuing orders, has suspended the contract. It's in the worst of all worlds. There's no official suspension, and it's not collecting anything, but it has to be there. As the official communications said that were periodically sent by Mr. Gomez to the contractor, you have to be ready in case I send you a work order. It's a situation where the contractor's situation is quite weak. They're there with all of the equipment ready to go to see if it might occur to them to send a work order, which didn't happen for very many days. That's where I see the contract allowing for a margin of abusive conduct that would seem to be incompatible with the clause in Article 3. Don't you think so? Well, I still don't think so, because when one enters into contracts of this sort, the starting point is that the provider has operational capability and financial capability, and that means, for the purpose of this contract, that they're going to have the capacity to financially put up with the situation. I believe I heard from the lawyer that this translated into a cost of $200,000 a month, what they had to be spending, independent of whether that's true. I'm not familiar with the evidence of that, but $200,000, that's 400 million pesos a month. It doesn't seem to me that for a provider with a solvent financial capacity, that is, for example, owner of the equipment, owner of patents, that has the capacity to take on that expenditure, and subsequently, in a healthy period of the contract, that money that you're spending is going to be compensated once you reach the minimum amount. So what you are helping me see, and mindful of the theories and arguments that have been put forward by the claimants, perhaps yes, they might have had poor financial and operational engineering in terms of how they were going to carry out the contract, but that's not the fault of PEP, that is the fault of the provider. Well, since time is marching on and my colleagues have more questions, this is interesting for in the judgment that put an end to the annulment proceeding, the judges there say that there were no suspensions, that the contractor has not shown that there were any suspensions of the works. And so that's why I wonder if we're talking about suspensions in the official sense of Clause 17 or de facto suspensions. But, well, I believe that Alan has a question. Alan, please go ahead.
It is related to what you said before. You said, Mr. Lusteno, that I can never read me again. A well can be drilled even when there is no authorization. I am reading your contract. I am a very prudent man. If you read your contract, there are many provisions which would advise you to be very, very prudent. You just have to start with 4.1. The contractor undertakes to execute works object of this contract in accordance with the work orders that PEP issued to it within a period of execution. Then we can, well, there are several interesting clauses, but more or less linked to that. But we can jump to clause 13.2, and in there you can read, when you get it, there. Oh. So 13.2, second paragraph I wrote. During the extension of the works, well, yes, the issued by the PEP or it or the contractor becomes all aware of the need to execute, then for a period not exceeding 5 days, you can plead for additional amounts of work. But it is clear that in the event that PEP authorizes the execution of the works, the contractor, within a period not exceeding 10 days, must submit the resident of work for a review of proposals of the terms, etc. And again, we go to 13.2.1. The contractor may only execute the works provided for in this paragraph once he has the authorization in writing in or in the log by the resident of work, with the exception of emergency situation. So I must say, and then you again have several clauses which are related. If the contractor performs work for greater value than that stipulated in the work order in question, without written authorization from PEP, regardless of the liability incurred for the execution of the surplus work, it will not be entitled to claim any payment. So I think if you have all these provisions in mind, and on others, these ones are probably the most right to the point, but the general impression I had just reinforced that. So is it really true what you said, rather clearly but toughly, that a well can be drilled when there were no authorization? Would a cautious operator say, "Oh, I have no authorization, but I drill"? Citing you.
Sí,
Yes, I think that these clauses that we read speak of the authorization issued by PEP to the provider. And indeed, with respect to the provider, the relevant thing is that PEP authorize the work being proposed. And in this exercise of looking at hypotheticals, had the well been drilled, had the providers not abandoned the contract, and had the well been drilled, and CNH then did not give the authorization, then PEP would not have been able to reproach the provider for that conduct. Having drilled a well without the authorization of the CNH is a form of conduct that would have had no impact vis-a-vis the provider. So vis-a-vis the provider, what is of interest and what is relevant is that PEP issue an order, and once it indicates how it's going to do the work, then PEP would authorize the drilling. And this makes sense because the National Hydrocarbons Commission supervises those who have, well, what we have at PEP are allocations, asignaciones. This is basically a concession granted by the CNH, and the CNH supervises the operator of that assignment or concession. It does not supervise the providers who are the main ones in the administrative act. PEP supervises. It supervises PEP.
Solo una pregunta, regresando al punto.
Just one question, going back to clause 17, which was the subject of the questions put by Mr. Conte. In the first paragraph, mention is made of a temporary suspension. It may temporarily suspend. And then there's a second sentence that says that if there's been a temporary suspension, it must be updated. And one must be kept informed of the time of the suspension. My question is twofold. If we have this clause that says may suspend, but then it says that such temporary suspensions will be subject to an updating, that they have to be updated, so as to then say, without prejudice, to being able to opt for early termination of the contract. I imagine PEP, but perhaps the contractor as well. Well, couldn't it be said that there's an implicit obligation to keep the contractor informed? so that it can act, because then the next paragraph says PEP will communicate, indicating the causes, but also the date of its initiation and the likely resumption of the work, as well as the actions that should be considered in terms of machinery, personnel, and so forth. So this suggests that the contractor has to be kept informed, and it occurs to me that if there is a temporary suspension and you say that there's a minimum requirement, then at least the contractor could calculate, once the time comes, when one may be infringing the minimum amount, and the contractor could say, I have so many days left, and even if our activity is maximalist, we're not going to achieve the minimum value. And at that point, they could say, we're reaching a point where with this temporary suspension, you may well be violating my right to a minimum. So is there not there's this implicit obligation, it appears, to inform, and second, a requirement to give the contractor the possibility of protecting its right to a minimum amount. Well, I don't see this obligation to inform. What I do see is that the provider should maintain the capabilities so that once a work order is issued, it should be ready to carry it out, mindful of the total time of the contract and the minimum amount. I don't see any part of the contract imposing a burden on PEP to say, I will maintain the provider informed of when you think you're going to issue work orders. Well, in that case, my question is, from the standpoint of interpreting the effet utile of a clause, if you look at the second paragraph, if it's as you say, then the second paragraph would be of no utility whatsoever. The thing is, this clause, the second paragraph, refers to when PEP carries out the exercise of its contractual right to suspend. Here in this case, that suspension was never effectuated. And why was the suspension not effectuated? Because the contract allowed you to, indeed it provided for the fact that as between work orders, X days could elapse. I go back to the previous point. Let's imagine that this temporary suspension is so lengthy that it begins on day 1 or day 2 of the contract, and it goes out of a 100-day contract to day 99. Well, obviously in one day, the contractor would not be able to produce the minimum amount. How can you render compatible the right of PEP to not have to issue any sort of suspension with the right of the contractor to perform a minimum of work? What must the contractor do, and when does the contractor have to know that it needs to act so as to be able to protect its right to the minimum amount? Well, once a period has gone by such that it'll be impossible to generate the minimum amount. I think I understand that would be 8 days, but we're talking about a hypothetical scenario because that's not what happened. Here, what happened was, well, when a work order is issued, the provider, as I understand it, once it was issued, it had already abandoned performance of the contract. Moreover, it could not. There was such a difficulty, and that's why I speak of abandonment, of even notifying things. And this concept of suspensions which was never the case. This special power to suspend the contract was never drawn upon. But, mindful of your question, I think it is compatible for no work orders to be issued so long as the minimum amount is respected. And it seems to me that it could have been accomplished because the contract still had a year left on it when the work order was issued. I'm not sure how much time remained in the contract once the work order was issued. I think it was in 2016, and if I'm not wrong, the contract was to be enforced until 2017. So it had a year to reach the minimum amount. That didn't happen because the provider abandoned performance on the contract, so much so that they could not be found anywhere to receive a document. And then there would not be the notes in the log book of the works. They didn't respond to emails sent to them. Now, if you allow me to continue exploring suspension, particularly to clarify what I meant by a special, which was not the invoking of Clause 17, but rather a de facto suspension without invoking Clause 17. But let us turn to Annex C97. It's the official communication that Mr. Gomez Herrera sent the contractors on 22 January 2016. And it says, in the fourth line, once the interventions currently underway are concluded, timely measures should be adopted for the purpose of being on top of the issuance of the next work order by PEP. That's what it says in the first of two paragraphs. In the next to last paragraph, it says, I don't fail to mention that according to Clause 17 of the contract in question, referring to suspension of the work, the time elapsed from the issuance of work orders for work by PEP shall not be considered as suspension of the work or of the contract. This is where I saw an interpretation of the contract that might be considered abusive or special. That is to say that PEP, instead of invoking Clause 17 at its own initiative, said, well, what I will do is I will stop issuing orders and I will fall under that provision, which is that there is no suspension from one order to the next, and therefore the right set out in Clause 17.1 to request non-recoverable costs doesn't apply to the contractor. That's what I think could be interpreted as a loophole or as an abusive power by PEP to carry out the de facto suspension. And this is especially relevant for this issue is addressed in the 4 October 2018 judgment in the annulment proceeding when, I don't know if you want us to show it to you, if I read it out in Spanish at page 228, the tribunal or the judges say, now the argument of the claimant has no foundation when it says that the works were intermittent and that there were various suspensions of the works. First, because, well, a number of official communications are mentioned where it says that that they must wait for a work order to be sent to them. But then on page 223, it's not clear. It says that the PEP has suspended performance of the contracts. It simply recognizes that PEP does not have budgetary sufficiency, and therefore it must talk to the service providers that once the drilling program is concluded, they should dismantle and transport the drilling equipment to the respective bases. So, as we see from the judgment, PEP not only did not send new work orders, but also between work orders, it demanded that the contractor take the equipment to its yard in Poza Rica. So my question is, that's in keeping with the contractual provision having to do with the suspensions, or is that not a de facto suspension that could be understood to be at least not in agreement with the spirit of Clause 17? Well, you've raised various issues. I think that everyone knows that, given the nature of the contract and what a contract implies, that has minimum amounts, maximum amounts, and that operates with work orders, well, I don't think it was any surprise for the provider that there could be time periods when there were not going to be work orders, and that those time periods were not going to be considered as suspension periods, so much so that there's an express provision of the contract so stated expressly. It indicated this, that if the provider did not appear either in a weighing of the risks of the contract, or even once the contract is signed, if it noticed that not being able to issue, the non-issuance of work orders would diminish its capacities for responding once PEP issued a new one, well, then the provider could have asked for a suspension. But as far as I can see, it never did submit any request for suspension. It responded in the periods of no work by when no work orders were issued, and that's how contracts with minima and maxima operate. This is not a copay contract. It's not a lease contract. It's not a take or pay or a contract, nor is it a leasing contract. This is a contract with maxima and minima that works with work orders. Now, if the provider didn't like the design, the engineering of the clauses of the contract, it could have said so. It could have not signed. Or, in the face of this period of inactivity and not issuing orders, it could have asked for a suspension. But as far as I understand, it failed to do so. And this leads me to conclude that there was never a genuine concern to raise this issue. A while ago, the arbitrator was posing an interesting question, which is what happened during these time periods. It would have been interesting that this did not happen. Then the provider could have sought a suspension, but that didn't happen. And the right to seek non-recoverable costs, including with a formally decreed suspension, that is to say, looking to the clause that talks about suspensions, the right to request non-recoverable costs doesn't arise automatically. It has to be shown. They have to show I think it was $200,000 that was mentioned, which was required for maintaining the contract. Well, if you invested those $200,000 monthly, where are those $200,000 monthly when you're issued a work order. Where were those $200,000, which is what it cost for them to be in a position to be able to carry out the contract. That's what leads me to think that there was abandonment of the contract because of a failure to properly weigh the situation, to properly engineer the operational and financial aspects. And here they thought the contract was going to go so well, but the reality is that the industry suffered with a sharp decline in the price per barrel, and that made it such that productive activity had to be curtailed, not only at Pemex, but around the world.
De acuerdo.
Okay, but if we go back to 17 and then 17.2, you said that the contractor could have asked for a suspension of the contract and for PEP to declare the suspension of the contract. But if I look at the first paragraph of 17.2, I'm trying to see whether it can be shown on the screen. And this is 17.2, first paragraph at C34. If I understand this paragraph correctly, PEP had the possibility of having the contractor not to ask for new things. Because if it says here, the request for recognition of the suspension and where appropriate, the request for payment of non-recoverable expenses must be presented by the contractor. And that it says within 20 days following the date on which the contractor resumes the suspended works. And it seems weird to me. So if the works were not resumed, and then the contractor could not ask for suspension. So PEP deprived the contractor from its right to ask for a suspension if it didn't issue a new order. At 17, it says that the suspension by PEP was a power of PEP, because it said PEP may temporarily suspend. It does not say must. You talked about the fall of the price of oil and that PEP was not interested in drilling, then it could resort to 17. So there was a loophole in this contract, an enormous loophole, because was PEP going to be so dumb as to resort to 17 of the contract and suspend the contract, and this will entail the contractor having the rights under Clause 17. So PEP under 17 said, okay, I'm going to stop issuing work orders. There is no official suspension. You cannot ask for a suspension, because a suspension can only be asked when works are resumed, and during all that period of time, you collect no money. So the design and the drafting of 17 is a little defective, and this could bring about abuses that should be weighed against the principles of good faith under Clause 3. But if we look at 17, literally, PEP could impose unqualified de facto suspensions that in practice had the same effects that a suspension of 17 would have. The difference is that the contractor would get no money. Agreed. This was a hypothetical that we conducted on the basis of the analysis of the suspension clauses. But what we do see happened in reality is that when we tried to issue a work order, there were difficulties to even provide notice of that work order, because the provider didn't answer our emails. It didn't really have a work log. We couldn't really go to the domicile and provide a notice at the domicile because they had moved. That is what indeed happened. So this is, in point of fact, what happened. Okay, there may be a blank space here, and you're saying that there may be the possibility of one party abusing the other party. No, I don't think that's the case, because these are contracts entered into by parties that are sophisticated and that are experts in the sector and that are familiar with the industry, that are suitable to enter into these contracts and to perform under the contract obligations and to assume the consequences of the documents that they execute. I don't think that looking at both parties, we can say that the contract had this optional provision that allowed one party to abuse the other party.
Any further questions before we give the chance to both parties to do follow-up questions after so many questions from the tribunal? So first the claimants and next respondent.
I'd like to go to Exhibit C104, please. Page 14.
Una disculpa, señor presidente.
Excuse me, Mr. President. Would claimants like for us to show the documents, or will the claimants show the documents?
But
We're working on it. If we could go to page 14, please. If you could expand the paragraph under 14, lista de verificación del equipo, the big paragraph. Mr. Lucena, you were questioned about this document a few minutes ago, and something caught my attention. If you look at the paragraph that starts with por lo anterior and read 5 lines from the bottom of that paragraph, it mentions the verification of an equipment, a drilling equipment called PMX 805. Do you see that?
Sí, lo veo.
I do see that, yes.
PEP was expecting Finley to drill the Coapachaca 1240 well with an equipment called PMX 805. Is that correct?
It appears to be the case, yes.
Let's go to Exhibit C98, please. Let's start with page 2. This is a document describing the equipment that was to be used to drill the Coapachaca 1240 well, correct?
I do not see what relationship there is with Copachaca. I do not see. Oh, okay. Yes, yes. Here it says subject for Copachaca 1240. Yes, they sent information, and this is a contract for Copachaca 1240.
Page, please. And if we could blow up, can you find PMX 805 on this sheet?
No.
I do not see that. I do not know what document this is making reference to.
I want to understand correctly from your redirect. To be clear, Pemex can rescind a $418 million contract for a PACMA violation that is less than $1 million?
I think the question is based on an incorrect understanding of the contract. This is not a contract of $418 million. It is a contract that has maximum amounts and minimum amounts. If there is a breach, well, we're talking about a hypothetical, right? Your comment has to do with a hypothetical because the contract was not rescinded exclusively because of a PACMA violation. If you're asking me questions about the contract, we can go and see what the contract says. The contract says that if there is a breach by the contractor, PEP may rescind the contract. In this hypothetical that you're putting to me, and that is not what happened in reality, I see that if there is a grounds for rescission, for example, in the case of the PACMA violation, PEP could have terminated the contract. This is not what happened here, though.
And I appreciate we disagree on the amount of the contract, but I'll ask you a similar question. Pemex can rescind a $418 million contract for an unfulfilled work order requesting work for approximately $1 million?
Yes.
Can we go to R32 again, please? But before we do, while we're talking about the work order, do you know why PEP stopped at just work order 028-2016? In other words, why didn't it issue another work order if it wanted us to perform work?
I don't know. I don't know why. I don't know why it ceased to issue work orders. I don't know why the administrator stopped issuing work orders. Perhaps it had to do with the fact that at the time it didn't see the need to continue to issue work orders. This was the maximum amount, minimum amount contract. So the parties had established that perhaps there could be period of times in which no work orders would be issued. This in no way would entail that the contractor would be allowed to disappear or to left unfulfilled a new order.
But if that happened 15 times, PEP could have administratively rescinded the contract under Clause 15.1R, correct?
According to 15R, yes, but something different happened here. What happened was a substantial breach of the obligations under the contract. That is to say, the drilling of wells. This, together with a contract behavior that showed that the contractor had abandoned the contract. There was a breach of the PACMA obligations, and there was also non-performance in connection with the criteria imposed by the contract administrator. From my viewpoint, and apart from any hypothetical that we can comment on, that conduct under the contract allowed PEP to exercise its right to rescind the contract. Apart from this exercise that we're conducting in this hearing, well, the contractor never argued about anything about the 15 orders when dealing with the 15R.
And
the contractor had a number of opportunities to call into question the validity of the rescission of the right to rescind, but it did not bring up this issue of the 15 orders. So I think the exercise that we're doing here is valid from a pedagogical viewpoint or educational viewpoint, but this was never discussed in any of the litigations that examined the validity of the rescission.
Are you sure that the issue of Clause 15.1R was not raised to the administrative court?
This is the first time that I've heard of that. I've heard it here. I am sure that it wasn't put to it.
Turning our attention to R32, now that we have it. We talked earlier about how the board issued this order. Do you remember our conversation?
Yes, I do recall.
And you, at some point, were in charge of reporting to the board as a result of this order, no?
I was not.
Did the board expect to receive reports of whether its order was being complied with?
Yes, but this was not an activity that was within my purview.
Would the board want to know about the administrative rescission of a $418 million contract?
No. Nowhere in this resolution do I see an obligation to report to the board the rescission of a contract of any amount whatsoever, 10, 20, or $418 million.
What I asked was, would the board expect to know about the administrative rescission of a $418 million contract?
I would not be able to answer that question. I cannot know what the board expects or does not expect. In my experience, the issues that I put to the board and reported to it are issues that have to do with risky matters, delicate issues. This in the field of litigation, where one sees that the assets of Pemex may be compromised. And this matter that I had to deal with did not have those characteristics that led me to report to the board a litigation.
It's a very long answer. So you say no. No one told the board of directors of Pemex about the administrative rescission of the 821 contract?
As far as I know, no.
Es que quizás podría.
It may seem, perhaps, that this $480 million contract is a contract that is very relevant. But this may be for the contractor, but for the budget of PEP, a contract of $418 million for PEP's budget, well, is not relevant, so that a rescission has to be reported to the board of directors. The board of directors is a decision-making body, and it does not need to get reports on contract rescissions. Contracts are rescinded in Pemex and suspended and terminated early all the time. That does not mean that a report should be presented to the board. The board presents policies and creates guidelines, but the board of directors does not need to get reports on a specific matter unless the matter is risky or that it may impair the assets of Pemex. This was not the case.
And I want to be very specific, and I'm talking about contracts similar to or just like the 821 contract. How many of those contracts has Pemex rescinded?
I don't have that information, but what I can tell you is that contracts are rescinded and terminated all the time. The number of contracts that Pemex has is very large. It's not that Pemex is seeking to rescind contracts, but amongst all of the contracts that Pemex has, sometimes there are breaches. So this means that contracts are being rescinded all the time.
I like.
Excuse me, Mr. Mersheimer. I need to make you aware that we are not in a new cross-examination, but just in follow-up questions.
That's fine.
Okay.
I'd just like to be very clear, though. I appreciate that Pemex has rescinded contracts. I'm asking a very specific question. How many contracts, like the 821 contract, has Pemex rescinded?
Tiempo. Ya respondió.
Mr. President, because of a matter of time, I can tell you that this question was asked and answered. This is a redirect or the redirect or the redirect. If you can please repeat the question, or rather repeat the answer. I have no personal knowledge of that.
No.
Señor Bonfiglio, el follow-up.
Mr. Bonfiglio, any follow-ups? Thank you very much, Mr. Lustanov. I'm going to be very accurate. I'm going to ask just a couple of questions, follow-up questions, questions related to the ones posed by the tribunal. Questions were asked of you in connection with the meetings that a litigant may have with a judge or with a justice official to put to them the position of the client. Do you know whether someone from Pemex or from PEP met with this alleged judge in charge of the annulment proceeding related to A21? I do not know that, no. Okay, agreed. Next question. At any rate, Drake Finley, as a contractor, and specifically as a complainant in that annulment proceeding of 2017, could they have met with that judge to put to it their case within the context of the 2017 annulment proceeding? Isn't that the case? Yes, of course. What's more, we were at a disadvantage to hold those kinds of meetings because of the large number of matters that we need to attend to. It is difficult to follow up on these ex-parte communications, ex-parte meetings. In my experience working for Pemex, I've seen that when a contractor has a case against Pemex, that case becomes very relevant, and they are there day and night at the courthouse. Well, that's an exaggeration, but they're there weekly trying to make their point. When a matter is in its latest stages, or when it is at a stage where a ruling is imminent, I ask my lawyers to let me know so that we can talk to the judges or to the justices. I think that they were in a better position than we were to conduct those meetings. Thank you very much, Mr. Lustanov, member of the tribunal. Mr. President, we have no further questions.
Pues yo creo, señor Lustanov.
Mr. Lustanov, thank you so very much for being here today and also for your stamina that you have shown during this very long session.
Because now I think we need to make a break for lunch, and we need to come back because at least the tribunal has or at least some members of the tribunal have some questions on general issues that are a follow-up of day one, and we didn't have enough time, and so now we'll have an opportunity for two parties to express their views on issues which are relevant for the tribunal. So it's now what? So 1:30, so we reconvene at 2:30? Okay.
Muchas gracias.
Thank you very much to the members of the tribunal. Thank you very much to the members of the secretariat, to the claimants, to the Minister of the Economy. This was truly an enriching exercise professionally, and I hope that this was useful to you as well. And we said that we were going to finish at 1:30, and that's exactly what we did. We ended at 1:30, so you can catch a cab and go to the airport. Thank you very much, Mr. President. Thank you.